pursuant to the subpoena. The DOJ has failed to provide specific information in response to repeated requests from Democratic oversight staff as to why the DOJ's timetable continues to move and why it's not fulfilled its production or the law. Now, in response to letters from our committee on November 25th, the DOJ transmitted a single letter in response to the committee's inquiries. They claimed that the DOJ was working to comply with the Epstein Files Transparency Act, which now, of course, we know they actually weren't doing because we actually haven't received very much. The letter made no reference to the committee's subpoena, no reference to DOJ's plan for compliance. The corrupt failure to comply with the Epstein Files Transparency Act is not just a crime, it also shows that the Attorney General has made no attempt.
More than half the committee, they were demanding that we subpoena the estate, and we did. We got every document from the estate. There were people who said, oh, there are going to be a lot of questions answered. There'll be names and all. We've subpoenaed every document, every picture, everything from the estate. We never held back. We've been serious. We've all supported the full release of the documents. As I've stated many times publicly, we wish the process was going quicker. That's a lot of documents, a lot of redactions, a lot of eyes have to be put on this. So the Department of Justice is complying. Now, with respect to Maxwell and the Clintons are not treated differently. Maxwell was always, she was willing to appear, but made very clear she would take the Fifth Amendment. The Clintons refused to appear. The Clintons refused to appear. And one of the proposals that Clinton made was if we would let Hillary Clinton off, then Mr. Garcia and I could travel to Mr. Clinton's house and bring one staffer and take notes, but no transcript. That's not even a thing, and you all know that. The media, I'm sure, would require a transcript. There's no real investigation without a transcript. So, what few counter proposals the Clintons' massive legal team has made aren't acceptable, and I don't think anyone is going to stand up here and willing to publicly argue that they were. So does any other member seek recognition? Mr. Frost.
Thank you, Mr. Chairman. The American people deserve full transparency, and anyone who has relevant information about Jeffrey Epstein's crimes must be compelled to come forward and share with this committee. Wealth and power cannot shield people from accountability from this committee. It is the victims of these horrific crimes who deserve protection, not Jeffrey Epstein and the people associated with him. We all agree. We want to hear from former President Bill Clinton. But committee Republicans have failed to conduct a serious investigation. For instance, they refused to hold Attorney General Pam Bondi in contempt for failure to release 99% of the Epstein files on a bipartisan law that we all passed on the House floor, and B, that had a deadline. And B, they refused to hold Ghislaine Maxwell accountable for defying this committee's subpoenas. We all know that President Trump has a long-standing relationship with Jeffrey Epstein. His administration continues to obstruct the release of the Epstein files for this reason. We've seen photos of them together. Even Elon Musk posted, @Real Donald Trump is in the Epstein files. That's the real reason why they have not been made public. President Trump's own Mar-a-Lago club appears to come up often in connection to Jeffrey Epstein. From reporting, we know that Epstein was deeply involved with Mar-a-Lago. He was a frequent visitor to the club for years. The club sent employees, usually young women, to Epstein's mansion for massages, manicures, and other spa services. Staff members from the club made frequent calls to Epstein's home in Palm Beach, and on these calls, Epstein engaged in sexually suggestive behavior, such as exposing himself. And in 2000, Ghislaine Maxwell recruited Epstein's trafficking victim from Mar-a-Lago, where she was working as an employee. This committee must also investigate what Mar-a-Lago club members and the staff knew about Jeffrey Epstein's crimes. Getting documents from Mar-a-Lago is about uncovering evidence, holding these people accountable, and doing right by the victims of these horrific crimes. So we are all for making sure that we hear from everyone. I don't care if you're a Democrat, I don't care if you're a Republican. I'm tired of rich people trying to evade justice and accountability, period. But you can't do it just for the party you disagree with. You can't do it in a politically motivated way. So here's the opportunity to show it's not a politically motivated thing. Let's also make sure that we get these documents from Mar-a-Lago. So with that, pursuant to Clause 2K6 of House Rule 11, I move that the House shall subpoena the Mar-a-Lago Club and all entities under common ownership or control with the Mar-a-Lago Club to provide the House Committee on Oversight and Government Reform with 1. All documents, communications, and materials related to Jeffrey Epstein, to include but not limited to personnel files and records, client files and records, massage and spa services records, complaints and grievances filed against Jeffrey Epstein, internal communications, and billing statements. 2. A list of all Mar-a-Lago Club personnel who provided massages on behalf of the Mar-a-Lago Club between 1997 and 2003, regardless of whether such personnel were contractors or formerly employed masseuses or otherwise. And 3, a list of all Mar-a-Lago Club personnel who were employed as or acted as managers of the Mar-a-Lago Club Spa between 1997 and 2003.
A motion was made by Mr. Frost. The motion is improper as the item is not on the agenda. Any other chair recognizes?
So Mr. Chair, you want to use procedure to push back accountability?
No, we're holding people accountable today. That's why we're here.
Well, why won't you move to make sure that we get the relevant documents from Mar-a-Lago? That I just read this, and you're saying it's because it's not on the agenda that we can't move forward with this? You have full discretion of this committee to say, you know what, let's have a vote in a bipartisan way to say we want the documents from Mar-a-Lago.
I don't have full discretion. It's in the rules. We vote on a rules package at the beginning of
You're able
Congress.
to say right now that we can vote on this.
We cannot vote on it. It's in our rules. We'll be breaking our rules. We have to apply to the rules too. We're not like the Clintons.
No. You are hiding behind process to protect these Mar-a-Lago documents, and I think it's disgraceful.
Chair recognizes Mr. Cloud.
Thank you, Mr. Chairman. One thing was noted in the Clintons' letters is they said the subpoenas were illegal. I'd be curious to know if the ranking member thinks that they're illegal. And with that, I'd yield the rest of my time to you.
Thank you, Mr. Cloud. I want to make sure everyone is aware. On February 11th, Attorney General Bondi will be appearing as the sole witness in front of the Judiciary Committee. Ms. Crockett is a member of the Judiciary Committee. I would assume, I don't want to speak for Ms. Crockett, but I would assume you'll ask her questions about the Epstein investigation and her progress towards releasing the documents. Mr. Massey is a member of the Judiciary Committee. He's already stated publicly he's going to spend his 5 minutes asking the Attorney General about the Epstein documents. So the Attorney General is slated to be in front of Congress, and I'm pretty confident that just about everybody on that committee is going to ask the Attorney General where we are with the document production. So I think that's important to note. February 11th, she's slated to be in front of the Judiciary Committee. And with the discharge petition, when the House voted for that, we issued the subpoenas for the Epstein documents. Then we all voted for the discharge petition. The discharge petition has jurisdiction in the Judiciary Committee. So she's going to be in front of the Judiciary Committee. The next week we're in session. So I think that's important to note. Do any other members seek? Okay, Mr. Lynch, then, yeah, go ahead.
Thank you, Mr. Chairman. I would remind the gentleman, and I'm sure he knows this, that the Oversight Committee is the principal investigatory committee in the House. And we have a responsibility. It may be a shared responsibility with Judiciary, but we nevertheless have a responsibility. And we are the ones who issued that subpoena. This committee did. We are the ones who sat with the victims, right? We looked them in the eye, including the Speaker of the House. We looked them in the eye, these women who have been struggling to get justice for many, many years, and we promised them, every member of this committee, we promised them that we would do everything under our power to make sure they finally receive justice. And here we are today. Now, with millions and millions of documents requested back in August, we've still received, what, 1% of the documents? This is evidence of wrongdoing in many cases. And yet we're allowing Attorney General Bondi to to obstruct justice, basically. Even the little bit of evidence that she has provided, she also included a statement that basically said, don't believe this evidence, there's a lot of falsity in these. I mean, I have never seen an attorney general in this country provide evidence and then give an opinion on that evidence to the legislature, to the Congress. That is unheard of. But it shows her willingness to do whatever she can to obstruct justice from being delivered. The second thing I want to say is, if we are truly interested in getting information relative to this investigation, there should be some underlying basis for that. And I have reviewed all of the evidence that's been made available so far. I find nothing that points to Secretary Clinton in this at all. Yes, she was Secretary of State at one point, but the information that we're trying to get with respect to Secretary of State is available from any Secretary of State that served in that office with respect to trafficking. So there is no direct reason, no direct evidence to point to Secretary Clinton in any of this. And yet, while those millions of documents are being denied us, we're pulling someone forward, I think, for the point of embarrassment, public embarrassment, and because of ill will on the part of the president, to bring her forward for embarrassment, but not for the purpose of gaining helpful information for this investigation. Mr. Chairman, I'll yield the balance of my time to the ranking member, Mr. Garcia.
Thank you, Congressman Lynch. Mr. Comer, I just want to be just pretty clear about two things, and one particularly something that you said. Let me just start by saying that you noted in your comments that your concern and your biggest concern was the issue of the transcript. And I want to just go back really quick, because you and I share respect for subpoenas. You and I share that we want the former president to answer questions. Is that correct?
Correct.
Great. And so does every other member of this committee. We want the former president to answer questions of this committee. And we want not just the former president, but everyone to follow subpoenas of this committee. So let's agree on that. But to be clear, President Clinton, the former president, has submitted a signed declaration. He's offered to sit with you and me and answer questions. He's offered to have staff in the room to transcribe and be there while those questions are being answered. And his request was to do it in a dignified way. Your concern, as you brought up in your last comments, was that he was unwilling to do a recorded transcript. That's actually also not true. And to be clear, there's been public reporting, including in articles that came out over the weekend, that they have not ruled out a recorded transcript. I want to ask the president questions. Chairman Comer, I want to ask President Clinton questions. Don't you?
That's why we're here.
I want to ask President Clinton questions and a recorded transcript and with our members of our staff. Would you like to do that also?
May I make a comment on the transcript? They have not agreed to a transcript. Staff notes are not equivalent.
They've actually made public reporting.
So they're wanting me to make note. They said, okay, Comer can take notes, but they've called us all liars, and you know how the Clintons have gone on offense, and look, they don't get to make the rules. We make the rules.
Can I have the rest of my time back?
Yeah.
Okay, thank you. I want to be clear, because this is an email actually that from the Clinton lawyers. You have this actually. To be clear, at no point were we opposed to the creation of a record of the interview, which is why we offered to allow the note takers previously. They go on. You have this email, sir. So I guess my question to you is, do you want to sit down and ask President Clinton questions? Actually, can I have my time back?
Will the ranking member
We'll recognize Garcia, then Mr. Donald will be next. So
thank you. So my question to you, Mr. Comer, again, is if we want to actually ask questions of President Clinton, of which those of us in the minority want to do, then let's get him in. Let's negotiate a recorded transcription of that interview to further our investigation. I thank you for the yield, Mr. Lynch.
Time's expired. Chair recognizes Mr. Donalds.
Chairman, point of clarification. Both both President Clinton and Secretary Clinton were subpoenaed by this committee to come in for a transcribed interview. Is that correct?
For a deposition.
Excuse me, for a deposition. Chairman, I've been in these closed depositions a number of times in my time being on the Oversight Committee. I fail to see what President Clinton's talking about with respect to a dignified manner. Every time I've been involved in any of these conversations, even when it was former President Biden's son came in for one of those, and I'm not trying to bring up all the Hunter stuff, it's just a point I'm making. I think everybody just take the temperature down, relax. Even those the closed door depositions have always been held in a dignified manner. Members have had questions outside of questions from committee staff, but members on both sides of the aisle had an ability to answer those questions. Those interviews are recorded. The transcripts of those interviews are provided to the public. I fail to see what special accommodations President Clinton and Secretary Clinton were looking for. Chairman, can you help me understand this? Or even a ranking member. I'm really trying to understand. I'm not trying to make a point. We do too much of that here. I'm trying to understand, because if we're holding a new meeting to replace what the committee already requested, my question is why?
Mr. Garcia is willing to answer the question.
Yeah. Thank you, Mr. Donalds. I appreciate the question. Look, I think the committee first, I'm not here to defend the Clintons, to be clear. That's their job is to negotiate with the committee. And in this case, you have the majority. Their job is to negotiate with the majority on coming in for a binding subpoena, to be clear. But I'll also note that this committee has historically made accommodations for a variety of folks. In fact, I think it is a bit hypocritical that when this very subpoena for the Clintons were actually made, I believe there were an additional 5 to 6 other subpoenas that were issued to numerous other members of former administrations, attorney generals, and so forth. Every one of those other subpoenas, I think maybe with the exception of one, were given special accommodations. In fact, they were actually allowed to just send their responses in writing. Is that correct, Mr. Comer?
That is. May I respond to that?
Yes, in just one second. And so accommodations are made. And so while every other folks in that group were given special accommodations, that's been typically the case. And I'll finally say just this. Like you, I want to have President Clinton answer questions. I think they are trying to negotiate that with the majority, and they have been clear that it being transcribed is not an issue. They've not ruled that out. And so let's negotiate with the Clintons and let's get them to answer our questions.
I mean, Chairman, since I guess we're on my time, and by the way, ranking member, thank you for that. I appreciate that. Chairman, you were mentioning you were going to inject your commentary with respect to special accommodations that have been made for previous witnesses. I don't know if you want to expound on what the ranking member said or not.
I would love to. So, first of all, you talk about ongoing negotiations. We have been negotiating for 5 months. This is clearly a stall tactic, hoping that the time clock runs out and the House flips and that you all let them off the hook. But secondly, you mentioned, and I mentioned this in my open statement, there were names on that initial list with the Summerlee motion and the Scott Perry amendment, Attorney General Holder, Lynch, Sessions, and Garland, as well as Comey. They all complied and had written statements under the penalty of perjury that they had no knowledge of anything with Epstein, that they weren't directly involved in the investigation, and basically had no personal relationship. I think we would all agree the Clintons had a personal relationship with both Epstein and Maxwell. It's from the evidence that we've received thus far from the estate and all the other documents that we have thus far, it appears that Jeffrey Epstein visited the Clinton White House 17 times while he was president, and then post-presidency, it appears that Bill Clinton flew on Epstein's plane at least 27 times. So there's a huge difference between the knowledge and relationship with the Clintons and Epstein and Maxwell versus the former attorneys general. And another note, I don't know if it was Mr. Bell or whoever said that we only are interested in Democrats. We grilled Bill Barr and Alex Acosta, and they are very Republicans. In fact, they were members of the Trump cabinet. Now, I've been on the Oversight Committee 9 years. We've had 4 other committee chairs. We've had Jason, since I've been here, we've had Jason Chaffetz, Trey Gowdy, Elijah Cummings, and Carolyn Maloney. I don't ever remember a time, and I could be wrong. If I am, I'm sure you all will correct me, but I don't remember a time when Carolyn Maloney or Elijah Cummings subpoenaed a high-ranking Democrat to come in for a grilling. So to imply that this is partisan, that is just simply not true. We've already had 2 very the former Attorney General of the United States under Trump and the former Labor Secretary and U.S. Attorney. So we've done that. And then one other thing with the Clintons, and I'll yield back. One of the arguments the Clintons made, Mr. Garcia, was that our subpoenas were unlawful. Do you agree that the subpoenas we issued the Clintons are unlawful?
I believe that all of our subpoenas that we have issued have been lawful, sir.
Okay. Just any other members seek recognition?
Ms. Brown, sir.
Ms. Brown. Ms. Brown.
Thank you, Mr. Chairman. It's clear to me that the purpose of this meeting today is just to continue this committee's agenda of political theater, plain and simple. Democrats have been very clear, abundantly, repeatedly, and without room for ambiguity. We want to hear from anyone who has information about the Epstein crimes. And yet, when President Clinton and former Secretary Clinton offered to cooperate with this committee, to submit sworn statements, to provide what they know, to engage in good faith, the majority said no. And that's what brings us to why we're really here today. The majority is rushing to hold in contempt 2 private citizens who have demonstrated their desire to cooperate with this committee and who have called for the release of every file on Jeffrey Epstein, all while the Department of Justice and Attorney General Pam Bondi are breaking the law in plain sight. Here are the facts. The DOJ was required by statute to release the Epstein files by December 19th, 2025. The deadline has passed by more than a month. And what have we received? 1%. 1% is not compliance. 1% is not transparency. 1% is a cover-up. What about the 1% they actually release? We've seen redactions that are extensive, unusual, and very likely illegal. And what's more, the Epstein Files Release Act, passed by supermajorities in this Congress and signed into law by this president, required the DOJ to send a report to Congress by January 3rd, 2026. More than 2 weeks later, what have we received from the DOJ? Nothing. So if my colleagues on the other side of the aisle were really serious about uncovering the truth and government and accountability, we would be demanding answers from the administration. We would be demanding answers from Attorney General Bondi. We would be demanding the release of the 99% of the Epstein files still sitting at the DOJ. So I have some very simple questions. Where is the subpoena for Attorney General Bondi? Where is the hearing on DOJ's failure to comply with the Epstein Files Transparency Act? Where is the accountability for the redactions page after page after page? This vote feels less like oversight and more like a distraction. A distraction from the DOJ's lawlessness, a distraction from a broken promise of transparency, a distraction from the embarrassment of a co-equal branch of government choosing complicity over accountability, and a distraction from survivors who deserve this truth. If this committee is serious, then we must hold the Department of Justice accountable. Release the files, all of them, and stop playing politics with justice. Survivors deserve better. And with that, I yield the balance of my time to the ranking member.
Thank you, Representative Brown. I just want to Chairman, I want to just respond to something that you said. I think it's important. First, I just want to read the folks of who the subpoenas you have chosen not to enforce. Alberto Gonzalez, who we subpoenaed on that same day, I believe you did not enforce. Eric Holder, of course, former AG, did not enforce. Loretta Lynch, you chose not to enforce. Jeff Sessions, you chose not to enforce. Merrick Garland, who I think it'd be important to have answer questions, you chose not to enforce. Robert James Comey, you chose not to enforce. In fact, I have Attorney General Gonzalez's letter. It says, "Dear Chairman Comer, this letter is to confirm that consistent with my conversations with the committee general counsel, I have no present memory or decisions or conversations related to the investigation and prosecution of Epstein matter during my tenure as U.S. Attorney General." He, of course, was the Attorney General when the whole Alex Acosta U.S. Attorney matter was in front of a critical time in this investigation. Now, you chose not to enforce that because you mentioned that this letter is under penalty of perjury. The declaration that Clintons also made and sent to you to answer some of those questions were also under penalty of perjury. I just want to clarify that. And then with the remainder of my time, Mr. Chairman, I think it's important to note that you talked a lot about the importance of our subpoenas and that we should all support this committee's subpoenas. And I agree with you, sir, and I want to hear from the Clintons. It's also important to note that we have members of this committee, Congressman Jim Jordan, Congressman Andy Biggs, Congressman Scott Perry, who are obviously very outspoken, which we like to engage with. Now, they're not here, and that's okay. Now, you also know, sir, that all three of them defied legally binding subpoenas issued by the January 6th committee relating to their efforts to overturn the 2020 election. So we should be clear that the majority chooses to be very selective on which subpoenas they want to enforce or talk about. We have members of the majority that themselves have defied subpoenas. So once again, I ask you, Mr. Chairman, let's ask President Clinton the questions that we have. Let's have him come in and testify in a way that we can negotiate, and let's get all the release of the files done immediately. Thank you.
Would you yield? Could I respond to that?
Sure, I have no more time, but I'm happy to respond.
So you say we didn't enforce the subpoenas. We did enforce. They complied and testified under the penalty of perjury that they had no knowledge. Now, the Clinton declarations were short bullet points, almost like talking points. And the evidence is clear that the Clintons did have relationship with them. Now, again, I've said publicly millions of times, there's no one's accusing the Clintons of wrongdoing, but the fact that they were that close, and the fact that I've never seen a sit-down interview with Bill Clinton where he's answered questions about his relationship with Epstein and Maxwell like the current president has. So we have complied and enforced all of our subpoenas, 100% of our subpoenas. So I just want to make that very clear.
Can I respond to you, sir?
Sure.
Just to be clear, you're talking about two declarations. The declaration that you chose to use as something that you moved on to not bring him in was 1/6 the size of the Clinton declaration. I'm looking at the Alberto Gonzalez response to you, sir, that you chose to dismiss, and it is one sentence long. You just pointed out the Clinton declaration, which is 6 times as long. And so I just think you are using interesting points to make comparisons. Let's just be clear and get back to the facts. Let's bring President Clinton in to have a conversation with this committee. You are instead choosing to try to prosecute President Clinton and send him to jail, which is part of criminal prosecution, before having him answer questions to this committee. Him and his team have been trying to negotiate. We want to hear from President Clinton. I'm not sure that you do, sir.
You don't think I want to hear from President
Chairman
Clinton?
Comer, can I, Chairman?
But before I recognize Ms. Luna, who'll be next, I believe, are you willing to accept those bullet points as testimony, or do you want to hear from Clinton?
I want to hear from President Clinton.
Then I don't know what the point is of talking about their bullet points. I mean, that we all know they had a relationship. So.
Well, sir, I'm just responding to the fact that you mentioned that you're dismissing other legal subpoenas with 1-sentence answers, and you're the one that pointed out the Clinton's declaration, which is also under penalty of perjury.
Do you think that Eric Holder or Lynch or Jeff Sessions or Merrick Garland had more? I mean, do you want to bring them all in?
I would love to have former Attorney General Merrick Garland in front of this committee to answer questions as to why more of the files weren't released. I've actually said that publicly. And so, sir, I think what it comes down to is we all want to get to the truth. We all want justice for the survivors. And I think more information is better. And so I think our position is that it is clear to me that President Clinton is negotiating to come in front of this committee, and it may not be exactly what you and the lawyer and your team want to see as far as that negotiation, or you're not satisfied with the progress, but they continue to negotiate. They have not rolled out a transcript. Let's get them in front of this committee. Thank you, sir.
Chair recognizes Mr. Gill, then Ms. Luna. Mr. Gill has a bigger. Go ahead. No, Miss. Who's next? Miss Luna. Go ahead, Miss Luna. Then Ms.
Thank you,
Mays.
Chairman. I'd just like to remind the American people that I was the member that made the motion to hold Merrick Garland in contempt of Congress, and every Democrat voted against it. And in addition to that, 3 of my Republican colleagues voted against it, one of which did not come back because his voters decided that he was too swampy for them. So
Okay.
I'd just like to point that out. But aside from that,
Well, Ms. Luna, it's been pointed out to me you've already had 5 minutes. Somebody will probably yield you some time, so I've got to.
if I could just finish real quick. If we're looking to see why the files have not been released yet, look no further than the judge, Engelmeyer,
I'm sorry,
who's
Ms.
actually been
Luna.
responsible
I'm sorry.
for
If
denying
someone can yield you some time.
special counsel. I'm just saying, I'm making a point.
All right.
So this is all
So we
political
haven't
games
recognized the Republican on this. Miss Mace, do you want to be recognized?
That would be great, Mr. Chairman. I have a number of documents I would like to enter into the record this morning with unanimous consent. First of all, I want to ask my colleagues on the other side of the aisle to stop playing politics with justice. Not a single one of you voted for your own party to be held in contempt. I'm the only member of this body, of this committee, that has held both Republicans and Democrats alike in contempt for defying a congressional subpoena. So the hypocrisy is real, and I don't want to hear anyone on the other side of the aisle say no one is above the law here on this. We're talking about human trafficking, sex trafficking. We're talking about children, girls as young as 14 being assaulted, being trafficked by wealthy and powerful people. This is not political. This is personal. This should be nonpartisan. We should be working on this together. And it's incredible that we're politicizing rape, or politicizing sex trafficking, or politicizing this entire Epstein thing. And it just, as a survivor, I'm telling you, it should not be. And I've done a lot of work, Mr. Chairman, in advocacy and writing legislation for victims of abuse, male, female, and children, man, woman, and child. South Carolina, my home state, Mr. Chairman, has a huge problem with with all sorts of violent crimes, but sex trafficking in my state is up by over 400%. We have domestic violence in our state where you can't get a trial. And there was a case last year where a woman 2 years ago was kidnapped by her boyfriend, beaten to a pulp, her face just beaten in. 2 years after he kidnapped her and beat her, he murdered her on Mother's Day because our local solicitor refused to prosecute that case. And I have rogue solicitors and prosecutors and attorneys general who aren't doing anything to protect the people of South Carolina, women and children especially. Recently, my attorney general prosecuted a case against convicted pedophile Donald Gresh. Donald Gresh was convicted of having 1,900 images of toddlers as young as 3 being raped by animals. Donald Gresh, under the prosecution of my Attorney General Alan Wilson, served 1 day in jail. 1 day. Donald Gresh isn't the only pedophile, convicted pedophile, that we prosecute like that. My Attorney General Alan Wilson prosecuted this case. This is Travis Reed Gay. Well, the other thing, too, is that Donald Gresh, he was facing 60 years in jail, got 1 day. Travis Reed Gay was facing 70 years, 7 charges and 70 years in jail in South Carolina. My Attorney General prosecuted this case. He pled guilty in November, didn't serve any time. He got probation. He violated his probation 11 days later, and if he violated his probation, he was to serve time in jail. The magistrate or judge, probably didn't have a law degree, let him out hours later. He has not served any required time for this kind of thing. And I did a press conference with a bunch of moms, over a dozen moms last week in Charleston, South Carolina, and there was a local media blackout. I asked, was it my attorney general who prosecuted this case and led this pedophile out on the streets? Was he the one that led the media blackout? Well, I want my attorney general in my state to know that a young child came forward after seeing my press conference and recognized this man. She filed a police report the same day because he allegedly followed her in a park the week before. This is Scott Spivey. Killed, shot with a bullet in the back, shot at 17 times. Not prosecuted by my Attorney General. So I'm going to ask unanimous consent, Mr. Chairman, to enter those 3 images into the record. This is Weldon Boyd. This is Scott Spivey's killer who shot him in the back and has never really been investigated or prosecuted for that killing in South Carolina. I would like to enter that into the record, Mr. Chairman.
Without objection, so ordered.
This is Logan Federico. She was executed a year ago, yesterday to the day, by a man named Alexander Dickey. Alexander Dickey was a convicted criminal. He had 39 arrests, 25 felony charges. He executed this beautiful 22-year-old daughter of Stephen Federico in cold blood after stealing a gun. If her killer, Alexander Dickey, hadn't been let out by a rogue magistrate or judge or a prosecutor solicitor that didn't care, she would be alive today. Mr. Chairman, I would like to enter her image and her killer's image into the record.
Without objection, so ordered.
I have another image. This is Eric Bowman. Eric Bowman beat his wife and has been alleged and is being investigated for other abuses against women and potentially underage girls. He was just let out free, Mr. Chairman, out of jail in South Carolina. He is a predator. I have reported him to law enforcement. He's under investigation, but I have written bill after bill about predators like Eric Bowman, about voyeurism, about these sort of criminal sexual allegations. I would like to enter his image into the record.
Without objection, so ordered.
I have 2 more.
Can we get it? Your time's expired, but I'll recognize you for a UC later on, because I want to make sure everybody stays within their 5 minutes. Chair recognizes Mr. Bell from Missouri.
You know, first and foremost, I think we're doing a disservice to the victims in this case when we refer to it as the Epstein files. It's sex trafficking evidence, and let's call it what it is. And as a prosecutor, we prosecuted these kind of cases when I was DA back home in St. Louis County, and I met with every single victim and victim's family because I wanted them to know that I was here for them, and I thought it was important that we look them in the eye and let them know that we're going to do everything we can to bring them justice and treat them with the dignity and respect that they deserve. And this is no different. That said, I think in D.C., what I've learned in my 11 months here is that this D.C. disease that of staying in this partisan bubble is something that you have to continue to be aware of, so that you don't fall into these same hypocritical traps. And I talked to Jamie Raskin because I just wanted to get some perspective on the law. And when we talk about the legal analysis, first and foremost, you can't read a statute. You learn this in constitutional law first day. You can't read a statute and understand the law. You have to understand how it's interpreted by the courts. And the courts have been clear that if there is negotiations, that does not meet the threshold for criminal contempt. And the examples are clear on that. When Steve Bannon was held in contempt, he did not negotiate, he did not reply, he did nothing. Meadows, when he started to reply, then Trump told him not to, and then he ceased with his communications with this body. And so in this case, I agree 100% with our ranking member. I want to hear from the Clintons. I think the victims we want to hear all the evidence. But what I know as a prosecutor is that we don't start doing depositions before we listen to the evidence. Now, if there's not evidence, okay, then there's other things to consider. But the evidence is here. There is evidence that has been duly voted on to be presented to the American people in a bipartisan manner, and of this evidence, we've received 1%. 1%. I mean, put this in perspective. There's 0%, and then the only thing you can do next is go to 1. That's it. We've got nothing. And now we're going to bring the Clintons in before we even have the evidence. That makes 0 sense, which is close to the one that I talked about. And so there's a legal analysis here. There's about what are we doing to ensure that we are doing a real investigation to get these victims the justice that they deserve. And so Ghislaine, whatever her name is, she needs to be brought into this body. And I'm hearing that, oh, well, she's going to plead the fifth. First of all, then let her. But secondly, legally on most of these questions, she can't plead the fifth. On grounds that she's going to be incriminated? She's already a criminal. So let's bring her in. Let's do those things. Let's bring in every single person. I don't care what they are, Democrat, Republican, and I've said this publicly, and my mother got on me about this. I don't care if my mother is in the Epstein files. We need to see 100% of the Epstein files to ensure that we are doing right by these victims. The illegal analysis does not support criminal contempt. A real investigation, a fair, bipartisan investigation would lead us to the conclusion that we want to hear from the Clintons, that we want to hear from everyone. But right now, we don't even know who else is in the Epstein evidence because Pam Bondi has not turned over that evidence. And that's the massive violation that we're seeing, that my colleagues on the other side of the aisle don't seem to have any urgency about. The massive violation of the law, and Pam Bondi needs to be here to answer those questions. But that is like, oh well, we'll put it off. We'll get there. We're working with them. I'll yield the remaining. Sorry, Ranking Member.
Hey, before I recognize Mr. Gill, I want to point out February 11th, Pam Bondi will be in front of the House Judiciary Committee. February 9th. I'm sorry, February 9th. February 9th.
February 9th is Miss Maxwell.
Miss Maxwell. And February 9th, we're deposing Miss Maxwell. February 11th, Pam Bondi will be in front of this committee. So there's a lot of wheels moving right now. Chair recognizes Mr. Gill from Texas.
Thank you, Mr. Chairman. I just think it's worth pointing out that the obvious reality here is that the Clintons are doing everything they possibly can to not come testify before the committee or have any real transcript or information about his engagement and involvement with Jeffrey Epstein over a long period of time. I mean, we've been working for 5 months to nail down a date for a deposition, working in good faith in the entire time. The Clintons have been evading this committee, at one point even deciding that they were going to propose Christmas Day, Christ's birthday, as a date for a deposition. I mean, that's not good faith. At one point, they proposed that instead of doing a deposition, they're going to have Chairman Comer and his staffer and a note taker go up to New York City, where they could ask Mr. Clinton questions and create 2 different sets of records about what Clinton said. That's obviously quite different than having an official court reporter precisely write down the words from the former president. Competing staff notes are simply not going to cut it. So we've spent 5 months working on this. It's about time that they comply with a lawful subpoena like many other people have. And there's some suggestion that we're selectively choosing who to enforce these subpoenas against. I mean, as you pointed out multiple times, Jeffrey Epstein visited the White House 17 times. He flew at least 26 times on Epstein's private plane. There's a clear, long-standing, obvious connection between the Clintons and the Epsteins, and I think we need answers for that. And I hope that we get that, and I hope that our colleagues on the other side of the aisle will join us in that. And with that said, I'm happy to yield 2 minutes to my colleague, Miss Anna Paulina Luna.
Thank you. I'd like to just say that I do agree with some of the sentiment of both my colleagues, to include Mr. Bell, who actually just spoke to wanting justice for the victims. But it's important to note that the reason why the files have been delayed in release is because of Judge Paul Engelmeyer in New York. This judge specifically ordered the SDNY to do a second review and for those documents to then be certified by U.S. Attorney Jay Clayton. So if you want to get mad at someone, look no further than Judge Paul Engelmeyer, who then also, at the same time, just denied Massey and Ro Khanna's motion to appoint a special master. So we can argue back and forth all day long about where the files. I want to see the files too. I want everyone to come in and answer questions. But look no further than this person. By the way, this person is not a Democrat or Republican. I think this person actually might be an independent. But if you're wondering where the files are at, that is the truth of the matter. That's it. As soon as those files come out at the DOJ, we're going to get them. And by the way, I will remind people that weren't here earlier, Todd Blanche will get on a phone call with people here. And after this, I'm going to go walk over Todd Blanche's cell phone number to Chairman Garcia and to Chairman Comer so they can both get on a call. I think it's important to open dialogue, okay? But the point is that we have to know the facts, and those are the facts. So look no further than Judge Paul Engelmeyer. Again, he's the one person that appointed the review, a second review, and then once those documents are then reviewed, then it goes to the DOJ. But you can't fast track the process.
Ask a question?
Yes.
Okay. Are you suggesting that the reason for not receiving 99% of these files is this judge? Not 20% of the files, 30%, half of them, 99% of the files, some of which are already public?
From what I've been told, and this is why I would encourage you guys to talk directly to the DOJ on this, is that there was a second review ordered. I don't know who all is in charge over in New York specifically doing that second review, but I do know that at least with the DOJ, they are officially done reviewing all the documents that they had left, right? They had 500 attorneys. I actually said this earlier, that NSD, Southern District of Florida, SDNY, and the FBI, there's 500 lawyers working on this to review all the documentation. They're officially done with that. Now, I don't know what the second review process is because I'm not internally at the DOJ, but what I will tell you is when you have this judge then also turning around and denying Ro Khanna and Massey's motion to appoint a special master, which I think Mr. Khanna can probably speak on, I think that that's shady. And I think that it's really terrible that we're sitting here arguing at each other, pointing fingers, when it's this one guy who no one seems to be mentioning that's actually stonewalling it. So I'm here for it. I want all the documents, and I do think that we're going to get those documents. Do I think it's going to be rushed? Absolutely not. I don't want to rush the process, but I will also encourage you guys, just as I did this morning, I got a victim's specific information. The DOJ has said that they will release whatever files they have pertaining to her directly, and she had not up until recently been able to, I think up until today, get that because frankly, a lot of these victims' portals go to just, I think, empty inboxes. But the point is that it's important for context. So I yield my time.
A question for the chair.
Well, you're Rick.
Before I begin, I have a question for the chair. I just wanted to clarify, when you said Pam Bondi's coming on February 11th, is she coming to this committee?
She's coming to the Judiciary Committee.
So is she coming to this committee at all?
Well, we'll see how the Judiciary...
Is she scheduled to come to this committee at this point?
I've said she's not scheduled to come to the committee. She's coming in front of the Judiciary Committee.
Okay.
Chairman,
Chair, you're recognized, Mr.
I'd like to yield 30 seconds to Ranking Member Garcia.
Thank you. Just really briefly, I appreciate Representative Luna's interest, I know, in the survivors. So I do appreciate that. I just want to be very clear and clarify. Judge Engelmeyer has nothing to do, his rulings have nothing to do with the legal subpoena passed by the Oversight Committee last July. Pam Bondi and Todd Blanche and the DOJ have been in defiance of a legal subpoena of this committee that has nothing to do with the Khanna-Massey law that keeps getting referred to. And so when you're saying that Judge Engelmeyer is the reason, that is actually not the case as it relates to the subpoena. And so they're still violating the law and have been since July, to be clear. Thank you, Mr. Min.
Thank you. And I just want to begin by echoing the comments of my colleagues on both sides of the aisle. As someone who spent my career as a lawyer, as a prosecutor, as a law professor, the rule of law is important. No one should be above the law, including presidents and former presidents, and congressional subpoenas are an important part of that rule of law. And I think the Clintons should be here. I think it's very shameful that they're not. But I also have to admit I'm very troubled by this criminal contempt motion. As a lawyer, I know that I don't know this area of law, criminal contempt. So what I did is what any decent lawyer does. I asked people who do know this area. I called a number of colleagues, former colleagues, people who are former DOJ attorneys, experts in this area. And it's hard to get 10 lawyers to agree on anything, but they all agreed that this was unprecedented, that under a normal administration, a normal DOJ that's not politicized, they would never bring criminal contempt charges in these circumstances. And I say non-politicized DOJ, because many of us are very concerned that this Department of Justice has become weaponized under this administration. Under Pam Bondi, we have seen them go after Trump's political enemies, including people like Adam Schiff and Latifah James with bankrupt charges. We've seen them refuse to investigate an ICE agent who clearly shot and killed a woman at point blank. We've seen them fire line attorneys who refuse to go along with indictments that they describe as political and illegal. Now, the closest comparison to this particular criminal contempt case is Steve Bannon. And there's well-established precedent here. Steve Bannon refused to answer, saying he would only answer questions from this committee if Trump told him to do so. That wasn't like delaying or obfuscating. That is willful defiance. And that's what the courts found, and that's why he went to jail. And again, while I think that the Clintons should be here, what we're proposing here is a very serious matter, bringing criminal charges against a former president of the United States. And I listened to you very carefully, Chair Comer, for the last hour, and I heard you describe them as delaying, as dragging their feet, negotiating for 5 months. But I never once heard you say they just outright refused to comply with the subpoena. And dragging your feet is not the same as noncompliance. It's not the same as contempt. And so if we think they're dragging their feet or obfuscating, there are lesser things we can do, including civil contempt. And I have to ask, like, why are we not thinking about alternative measures rather than bringing criminal contempt against a former president? And I also want to point out that on November 14th, and I want to ask unanimous consent to enter this into the record, Donald Trump wrote a Truth Social post in which he demanded that the Republicans go after Bill Clinton, Reid Hoffman, Larry Summers in relation to Epstein. Later that day, Pam Bondi announced that they would be bringing investigations. And now that we saw later that this committee brought subpoenas against the Clintons. This seems very political, and the people I talk to in my district view this entire matter as politicized. They view this as why Bill Clinton. And look, if Bill Clinton is guilty, let's put him in jail. But what I have a problem with right now is that we seem to be doing something that is unprecedented for Bill Clinton. We're bringing criminal charges against him, potentially, that we would not do for any other individual in these same circumstances. And that, again, is not my opinion. It's the opinion of everybody I talk to. It says it's not a close matter. And so I have deep concerns that this looks like a political witch hunt against Trump's critics, that it will be referred to the Department of Justice, that we have seen as politicized. Many of us had deep concerns that they are breaking the law on a daily basis. So I have trouble with this. I don't know yet how I'm going to vote, but I'd love to hear from you, Mr. Comer, why we did not pursue alternative measures, particularly when the Clintons, by all accounts, were actively negotiating, and whether you thought that their offers were not sufficient. They don't strike me as noncompliance or defiance of this subpoena.
Mr. Min.
Mm-hmm. Mr. Min, will you
think
yield for a question?
5 months? I mean, you just want to keep negotiating for 11 more months and hope.
Willful noncompliance is my question to you.
I mean,
why not civil contempt or
nobody's
something like
buying what you're selling. We've been negotiating for 5 months.
Why
5
not
months.
civil contempt or some alternative?
Can I make a
months.
suggestion, actually?
I don't yield my time to you. I yield it to Mr.
I've already
Chairman,
answered your
Chairman,
question.
I
can I
yield
make-
back then.
All right, Chair now recognizes Mr. Higgins.
Thank you, Mr. Chairman. Request unanimous consent to enter into the record the minutes of a hearing conducted by the Federal Law Enforcement Subcommittee on July 23rd of 2025, over which I presided as chair. That was the subcommittee, to clarify for America, where the original subpoena driven by the Democrats and Ms. Lee, the original motion to subpoena the so-called Epstein files was introduced. Unanimous consent to present.
Without objection, so ordered.
So within that is minutes. Here's the original motion from the Democrats. Move that the subcommittee issue a subpoena. Listen carefully, you alleged journalist and you, the beloved American citizenry that's paying attention to this. Move that the subcommittee issue a subpoena to the Department of Justice for the full, complete, unredacted Epstein files to be delivered concurrently to the majority and minority of the Subcommittee on Federal Law Enforcement of the Committee of Oversight and Government Reform. That's it. That was the motion presented by the Democrats. That motion immediately struck me as very poorly written because it had no recognition of recognizing and adhering to the existing long-standing criminal justice procedure designed to protect the innocent. It had no timeline. There was no timeline mandated in their own motion that would force the DOJ to comply with said timeline. There was no mandate for a particular percentage of release. There was no prohibition for actions in performance of compliance with their motion, which would become a subpoena from the Oversight Committee. It was not even the identification of Epstein. It just said Epstein files. Epstein who? You think the DOJ has not prosecuted more than one Epstein in the history of the DOJ? It was very poorly written. So, Republicans, noting that there were a lot of people missing from this, if we were going to do this, allow it to move, there were a lot of people missing. So Mr. Perry introduced, I remind my colleagues that this is my time. You recognize the decorum of this oversight committee. Perhaps you'll be recognized to speak. Mr. Perry introduced a motion to amend the motion to subpoena by the amendments to include William Jefferson Clinton. Imagine that, use the whole name. And Hillary Diane Rodham Clinton, amongst others. But of everybody on Scott Perry's list, the most defiant has been the Clintons, and the Oversight Committee has been very patient. I submit for the record, unanimous consent, I ask Mr. Chairman, the actual subpoena produced on August the 5th, at a hearing on July the 23rd, the subpoena was produced on August the 5th.
Without objections ordered.
Everyone has essentially complied to the wishes of the committee. Who's in control? We are. With a majority, we determine. The most defiant has been the Clintons. That's why we're here today. Back in July, after Scott Perry introduced an amendment to the Democrats' motion expanding the list to include the Clintons and others, including Republicans, Ms. Mace introduced an amendment to the motion to subpoena, saying, I move to amend Ms. Lee's motion to include the redacting of names of victims and any personally identifiable information of said victims and any possible child sexual abuse materials. And the subpoena itself, and I'm closing, Mr. Chair, the subpoena itself stated that the DOJ is to provide all the material requested and recognizing redactions required by law. So you're talking about 1 million documents. It takes time to redact 1 million documents. But the DOJ is performing and is delivering, and the Clintons are.
I'll give Walkinshaw an extra minute.
Thank you, Mr. Chairman.
But before we go to Mr. Walkinshaw, Ms. Mace has 2 more unanimous consent requests, and I'm going to give Mr. Walkinshaw an extra minute if everyone's okay with that. Ms. Mace?
Thank you, Mr. Chairman. I want to thank my colleagues, too. The whole Epstein saga and working with people on both sides of the aisle on the Epstein files and the working with the victims has been extremely enlightening.
Yeah,
this doesn't sound like unanimous consent.
You see, can you present the unanimous consent?
Oh, here's the unanimous consent.
Okay.
Through the Epstein thing, this is a tweet that I did about judges. I learned that, not all the judges have been forthcoming with information and files. I tweeted out on November 28th, impeach corrupt judges, especially South Carolina judges. I've done this about a dozen times or more. I'm guilty as charged. The last week an attorney named Robert Murding. I would like to enter his image into the record too.
Without objection, so ordered.
He is trying to hold me in contempt and told a judge should be thrown in jail for, among other things, tweeting out that judges should be held in, that judges should be impeached. This is what happens to survivors. This is what happens to victims. And I'm
sorry.
I would like to enter my predator bill into unanimous consent as well.
Without objection, so ordered. And
thank you.
All right, thank you. Chair recognizes Ms. Walkinshaw for 6 minutes.
Thank you, Mr. Chairman. I'll restate what others have said, which is that anyone who has information relevant to our investigation, including President Clinton, should talk to the committee. And I'm glad that he's agreed to do so. I have read, Mr. Chairman, that one of the sticking points in the negotiation between you and the Clintons' lawyers has been your demand that questions be asked about non-Epstein related issues. And it surprised me because I'm sitting here today listening to your intense interest in understanding more about the Clintons and their relationship with Epstein. So I'm curious why you have for 5 months demanded that you and other members of this committee be able to ask questions unrelated to our investigation of the Epstein files and Epstein's sex trafficking. And I'm happy to yield, Mr. Chairman.
I don't know what you're talking about. Everything that we've pertained to with respect to the deposition pertains to the Epstein files.
Okay, so you haven't demanded that the conversation, the questions be limited to the Epstein files.
The staff attorneys are communicating with the Clinton attorneys. That's the communication going back and forth. This investigation is about the Epstein files.
Okay, so you're willing, and you'll say here publicly, you're willing to have that conversation that limits the conversation, the questions just to the Epstein issue and files. Okay.
Yes.
All right. I think the Clintons' lawyers have been under a different impression, so we've made a little progress.
The Clinton lawyers are full of crap.
Made a little progress on the negotiation here today. Thank you, Mr. Chairman. We're 32 days past the statutory deadline and months since this committee's subpoena, and Congress has received, as we've heard, just 1% of the files. More than 5 million pages remain hidden. Instead of holding the Attorney General accountable for this failure, the majority is trying to change the subject today. Frankly, I find it insulting. We have to bring our attention back to the people who should be our focus, the survivors of Epstein's horrific sex trafficking operation, the women and girls who were exploited, abused, ignored for years. They deserve the truth, transparency, and justice without delay, without excuses, and without any political protections for the powerful or the wealthy. That's what we should be doing. Not scoring partisan points, not creating distractions, working to uncover the full scope of his crime so the survivors can see accountability. And if we're truly serious about justice, we can't ignore one of Epstein's most well-documented associates, President Donald J. Trump. We have documented communications, including a signed birthday note from Donald Trump containing explicit sexual references and referencing wonderful secrets between them. Emails from Epstein saying that Trump, quote, knew about the girls. Donald Trump acknowledging he knew Epstein was a, quote, creep and that Epstein recruited girls and women from Mar-a-Lago. Trump saying he wants to cover up the files because, quote, my friends will get hurt. If we're committed to transparency and justice, why is that off limits for this committee? Why is his name absent? Why no discussion of Attorney General Bondi's refusal to comply for months with this committee's subpoena? Why no contempt for Attorney General Bondi? What we're witnessing today is not oversight, it's not accountability, it's part of a cover-up, a diversion. And it didn't start today. Despite clear legal requirements in a law that Donald Trump signed, a subpoena that you signed, Mr. Chairman, and repeated public promises, Attorney General Bondi has failed to release the files. It's entirely within her control. And yet only 1% has been produced, more than a month late. And even that sliver is so heavily redacted that it mocks the law. It mocks the law. And it mocks this committee's subpoena. And let's be honest about the transparency that Attorney General Bondi has provided. This is DOJ Epstein data set number 4. It's number 4. Data set number 4. This is part of the 1% that folks have been talking about this today. I'll close with this. Attorney General Bondi and the Trump administration missed their deadline. They're ignoring our subpoena. They've withheld 99% of the files, and they have obscured the little that they did release. It's not a coincidence. It's intentional. It's about protecting one man, Donald J. Trump, from accountability. Release the files. I yield back.
Chair recognizes.
Mr. Chair, unanimous consent request.
Okay, I'll recognize you for that.
Mr. Chairman, I ask unanimous consent to enter the record a political article entitled "Clay Higgins Explains Why He Was the Lone No Vote on Epstein Files Release."
Without objection to order. Chair recognizes it'll be on our side, Mr. Perry, then Mr. McGuire. Mr. Perry.
Thanks, Mr. Chairman. I'm disappointed at where we're headed here. Look, I think that legitimately both sides want all the information. I know I sure do, with the proviso that the victims and innocent people are not damaged in the release of that. What's interesting to me is that the only time my colleagues on the other side of the aisle want to talk about any of this is when they can bring up the current president's name, but they're not interested at all in anything else. And I would just say this regarding the timeline, because I'm frustrated with it too. You know what would have been great? Would have been awesome if we could have truncated the timeline when the Democrat DOJ was in power under a Democrat president and there was any investigation whatsoever. Ladies and gentlemen, my friends on the other side of the aisle weren't interested in these victims at all when they could have done something about it. Nary a word was said, and certainly nothing was done. All this advance work could have been done by them had they cared. But this is not about caring about anybody. This is all political theater because they hate the current president of the United States. I get it. It's disappointing to me. These victims should have their day, and they should, all this information, regardless of who it touches, should be out, with the proviso that the innocent are protected. I know that's not of any interest to you. I get it. That's unfortunate. I yield the balance of my time to the gentleman from Louisiana.
I thank the gentleman for yielding. Mr. Chairman, earlier I asked unanimous consent to receive into the record the actual subpoena presented to the Honorable Pam Bondi by this committee regarding the DOJ's release of the investigative files on Jeffrey Epstein that was dated the 5th of August. I'd like to enter into unanimous consent associated with that entry, the letter written by this committee on August the 5th to Attorney General Pam Bondi, referencing the subpoena and giving specific instructions.
Without objections ordered.
I'd like to also enter into the record actually, I don't believe this has been released prior to right now, is the schedule associated with the subpoena. This is 1, 2, 3, 4 pages of specific instructions from this committee regarding the subpoena delivered on August the 5th. Now, unanimous
without objection to order
schedule as well. I'm sure the media will be fascinated with that. So the professionalism that this committee has pursued, to clarify for the citizenry, the professionalism that this committee has embraced and pursued has been squared away, impeccable. And that includes recognition that the Department of Justice, as stated in the subpoena, is to comply with redaction procedures of established law and criminal justice, long-standing procedures. So I heard someone mention 5 million files. That is the first time I've heard 5 million files. But I know that there were originally 250,000 files. And the Trump administration found another 600,000 files. So we were talking about, to round it off, 1 million files. Every one of those individual documents has to be reviewed by agents of the DOJ and their supervisors before they can be officially approved for release. That's the law. The DOJ has 400 agents working full-time on just releasing these documents. Now, you may argue that at the end of the day, you want to see the release of what they completed that day. I would say that's a fair narrative for discussion. But to say that DOJ is not fully engaged in complying with our subpoena is not accurate. It's not intellectually sound. And Mr. Chairman, I appreciate the opportunity to offer into the record these official and legal subpoena documents. I yield.
Without objection, so ordered.
Mr. Chair, I have a unanimous consent request.
Okay, Mr. Frost.
I have 2 articles. One is from Politics PA. Quote, Representative Perry referred to the House Ethics Committee for refusing subpoena.
Without objection, to ordered.
The other one's a CNN article. GOP reps Perry and Biggs formally object to subpoena from House January 6th.
Without
committee.
objection, to ordered. Chair recognizes Ms. Crockett from Texas.
Thank you so much, Mr. Chair. I have sat here listening and I am quite perplexed. It does take me back to my legal days. And so when I think about a subpoena, one of the things that we normally look at when we are trying to determine whether or not contempt is going to be ushered into the conversation is whether or not there's been substantial compliance and what it means to actually look like you have substantially complied. It means that you're taking reasonable steps to follow a court order, that you're acting in good faith, and typically that serves as a defense. So if we are still crafting the parameters of said subpoena, for instance, my colleague, Mr. Walkinshaw, just asked whether or not this would be limited to the Epstein subject matter. For me, if they responded at all, then there is some sort of compliance, which they did. They didn't just throw the bird. They didn't just say, forget it. But more importantly, I just want to point out that we are living in an age of hypocrisy, because my other colleague just pointed out that Mr. Perry sits here and somehow sits in judgment of others. Frankly, that is what people are kind of getting annoyed by, is the hypocrisy, because Mr. Perry still has an outstanding subpoena that was never complied with. In addition to that, he talked about we need to care for the victims. Somebody correct me if I'm wrong, and I will yield my time. But I don't believe that Mr. Perry ever signed off on the discharge petition in the first place. So I don't know if he is just doing what he believes is politically expedient. But I will tell you this. I refuse to be a puppet, because Democrats tend to be of goodwill. We always want to do the right thing. We are always trying to follow the rules and follow the law. Unfortunately, we are living with an administration that does not care. We just want some type of parity. So, for instance, we all want to hear from President Clinton. If for some reason you said, we will give you, say, Pam Bondi, and then we've got President Clinton with it, or say maybe President Trump and President Clinton, 2 presidents, because we know that both presidents actually had a relationship with Jeffrey Epstein. But what looks political and looks like one can get away with everything, especially since that's what the Supreme Court has stated, That's why it looks like it's just gamesmanship. You only care about following the rules so long as you can invoke those rules on what is typically perceived as your political enemies. This is why we are falling apart in this country. We are supposed to be about checks and balances. It should not matter whether or not you're associated with the Democratic Party, the Republican Party, independent, or whomever, whether you're rich, whether you're poor, whether you're middle class, whether you're a black immigrant or whatever. But it seems like we only have a political agenda in this committee, and that's why everything goes off the rails. You only love law enforcement when they're going after black, brown, immigrants, that kind of folk, right? But on January 6th, you didn't care about law enforcement because they still don't have their plaques up. We continue to do the right thing and say, yes, apply the rules equally across the board, and then y'all play in our faces and you only apply it to one side. I am asking for one commitment, and then I will yield to the ranking member. Mr. Chair, will you commit to me, as the chair of probably the most important committee in this Congress, especially in this moment where people are concerned about the level of corruption that exists within this committee, will you promise me that you are good for doing whatever is right and following the evidence, no matter who is on the other side of that evidence?
Yes, and that is why I subpoenaed the estate. And we had no idea what was, nobody knew. Nobody knew
I
what was in the
understand,
estate documents. And I, without hesitation, subpoenaed the estate. We've subpoenaed the Department of Justice.
And that's where we got the birthday letter. We subpoenaed
Because
the
of
estate. Hold on,
the
Mr.
subpoena,
Chair.
right.
Okay, we got the birthday letter, but we can't just get the evidence and then not follow up on the evidence that we actually get. I will relinquish the rest of my time to the chair.
Thank you. I just want to just really clarify one. Thank you very much, Representative Crockett. Just to back to Mr. Walkinshaw's point, I think it's important to clarify that in communication, Mr. Chair, with your team and the back and forth with the emails, the Clinton team made it clear that they wanted to answer questions about Epstein, but that was not something that your team agreed to, only about Epstein. And so that's, I just want to make sure to clarify, and I appreciate you clarifying, Mr. Comer, that you said that you would limit the questions to only Epstein. Is that correct?
That is correct.
I think
what
that's
the Clinton said that is not true. What their lawyer said is a complete lie.
Well, I'm glad that you clarified for them, because it's been their impression that it's been. I'm just telling you, it's been their impression.
He's paying them too much money then over the last 5 months.
And sir, I'm not. I'm just reading emails, and I'm just reading the back and forth between them and your team. It's been their impression that those questions were going to be beyond just Epstein, and so I'm glad that's been clarified. So thank you, Mr. Walkinshaw.
Chair recognizes Mr. McGuire from Virginia.
Thank you, Mr. Chairman. I agree with you. 5 months is plenty of time. The Clintons are doing everything they can to avoid questioning. And the American people want to hear from the Clintons. You know, Bill Clinton brought Epstein to the White House 17 times. He had him on, and Bill Clinton was on the Epstein airplane 26 times. So the American people want to hear from them. I don't understand why our friends on the left can't understand that. They support these crazy policies like open borders, 20 million people coming to our country. They've been robbing, raping, and killing the American people. You know, Lake and Rowley would still be alive. And instead of protecting law-abiding citizens, they defend the criminals, and they want to have a defund the police movement. It makes no sense. These criminals they put back on the street, recommit the same crime, and they're like, why'd they commit the same crime? All Americans have the same goal, the same American dream. We want to live, work, and raise our family in peace. We just might disagree on how to get there, but the Democrats seem to always be wrong. The American people don't want boys undressing in girls' locker rooms, but for some reason, the Democrats support that. 5 months is plenty of time. The American people want to hear from the Clintons, and they said they had no relationship, but they definitely did. And with that, I yield the remainder of my time back to Ms. Luna.
Thank you. I just kind of wanted to point out, first of all, specifically to the letter, the hand sketch that was allegedly the president's. I believe there's a $10 billion lawsuit that was filed that, according to the president, the organization that published that is actually trying to currently settle. So just to clarify. But aside from that, I wanted to actually ask Mr. Min a question, if he's here still, if he would be willing to vote for a contempt in the Clintons if they refuse to come in and testify on a fine of about $1,000 a day until they comply with the subpoena. but I don't know if he's here. Is he still here? No. Okay. Well, I think that that's just something to consider. You know, we have the ability to do those fines, and I think that that needs to be considered, especially if, you know, optically there is reason for pause for Democrats not wanting to vote for that based on the fact that President Clinton was a former president. I understand the optics of that, and I also understand re-elections. However, nonetheless, the Clintons are defying a subpoena, so sometimes financially people can be motivated, especially if there's a fine, and that's something that we actually all reserve the right to vote on. And I think that that's actually a very good option, especially being that most Americans would go to jail for defying subpoenas. And so I do not think that there needs to be any special accommodations made, especially given the nature of this, but I do think that that can be a tool to motivate. So I'd like to suggest that to you, Chairman Comer, also to you, Ranking Member Garcia, that would be a good method that we specifically reserve if we choose to use alternative means of contempt.
Representative, would you yield to me for a question?
Yes.
So it seems like you're open to changing this, what we're voting on today, so that way we can get to a place where we actually hear from them. Is that right? Is that what I'm hearing?
What I want, yes, I would like to have the Clintons coming into Congress to give a transcribed deposition.
Yeah.
I think that Chairman Comer has made that clear, but I also think having just Garcia and Comer drive all the way up to New York without that, I think that optically that sends a very bad message as the separation of powers and authorities Congress has. And then I also too think that, you know, it's kind of a slap in the face to people that typically would not have those accommodations made for them.
Yeah, yeah.
With that also, you know, being a part of this, I think that, you know, Bill Clinton specifically said he wants the files to be released. And I think that we also need to consider the fact that there is a judge. I know Mr. Garcia disagrees with me on this, but based on the email that I have seen on Judge Paul Engelmeyer, you know, if you have someone that is ordering the DOJ to do a second scan of the files, if it's politically motivated, that's impeding an investigation. And I'm tired of judges, if they get involved in investigations in Congress, trying to obstruct. And so I just putting this out there, I'm going to be trying to impeach that judge unless he can basically give a waiver, let the DOJ release the files immediately.
Yeah, and just real quick, I just want to say on the general thing, I agree. I mean, I think it would be best if the ranking member and chair can huddle and figure out how we can change it so we can actually hear from them. Because my concern too, and the other thing is, there's no faster way to make sure that we never actually hear from them in person than moving forward a criminal contempt that says put them in jail. I mean, we're just not going to hear from them for our investigation. And so, I mean, I agree if they can come to something to figure out how can we move forward in a way where we're actually, there's a pathway to hear from them. I'm for that. So
to be clear, I do not agree with what the Clintons are doing. Okay, and I think that they need to come in here to explain. But I do think that when you go after someone's pocketbook, I think that they quickly change
that we need. In addition, I am incredibly thankful as of President Clinton. I think that is all fair, and I hope that's the direction that
we got to this point. This was a series of deliberate decisions made at the highest levels in the White House and the Department of Justice to keep the truth hidden from the American public and the survivors of Jeffrey Epstein and his allies' abuse. Let's start with what the president said. During points in 2024 when running for office, Donald Trump said he would, quote, declassify the Epstein files, use it as a rallying cry to win over voters. In October 2024, J.D. Vance said, quote, seriously, we need about Jeffrey Epstein and his crimes revealed to the public. Starting in July 2025, Donald Trump began to gaslight the public. He said, quote, are you still talking about Jeffrey Epstein? This guy's been talked about for years. This is the point when Congress stepped up. On July 23rd, Congresswoman Summer Lee moved in this very committee to subpoena the full and unredacted Epstein files. And just to be clear, because of that subpoena, the Department of Justice and Pam Bondi have been required by law to provide the Epstein files to this committee since the summer of 2025. They have been in gross illegal violation of the subpoena this entire time. To my Republican colleagues on this committee, do you remember that subpoena, the lawful congressional oversight subpoena from July 23rd? At the same time, members on both sides of the aisle filed a discharge petition that would have put a vote on the floor for the Epstein Files Transparency Act. For a moment, the petition was one signature away from forcing a vote in the full House. And what did Mike Johnson do? He took Grijalva for a historic 7 weeks in order to keep her name off the list. He He forced the American public to endure a government shutdown to protect Donald Trump and to cover up the Epstein files. And when it finally came to the floor and it became clear that the bill would pass overwhelmingly, only then did he endorse and then sign the bill so that he wouldn't lose. This required the DOJ to release the unredacted Epstein files publicly by December 19th. The DOJ has blown past that deadline, releasing only 1% of the files, which is patently absurd. And the files they did release were heavily redacted, which is completely illegal according to the law. On December 23rd, the DOJ said they miraculously discovered over 1 million files related to Epstein. All of these patterns are an attempt to slow down the release and fail to meet the lawful deadlines are consistent and coordinated. This is all part of an intentional cover-up, which leads to the unavoidable question, who is the president protecting when we know he only cares about one person? I guess I'll end with my question to the chairman. The Attorney General, Pam Bondi, has violated the subpoena issued by this committee. We should be holding her in contempt to remain fair and to remain transparent. And so I ask that you do that if you really, truly want to be fair and care about the justice for the victims here.
May I respond? We have been very clear. We expect those documents. She has complied. She's turned over documents in the beginning.
1%
In the beginning,
not
you all
compliant.
complained and said the first document dump didn't have enough redactions, and the second document dump had too many redactions. So they're trying to get this, and I believe
Mr. Chairman,
that
with
we
all-
will get those documents
I
very
hear
soon.
you.
I have been assured
I
we're
hear
going to
you.
get those
If I could
documents very
respond.
soon.
I hear you, but with all due respect, given everything that she herself stated in February of last year, her own statements in front of the entirety of the American public saying, we have the documents. They are ready to go. The subpoena from this committee was issued in July.
And nobody
And
on
they
our
never
side,
got to work.
nobody on our side is defending Pam Bondi. I
So
can
then
assure
she
you.
should be held in contempt. If we are
She
going to
is
hold
complying with.
President
They have
Clinton in
turned
contempt, then we have to
documents
hold Bill
over.
Clinton.
They have turned documents over, and every time they do,
1%
you all
of the
complain
documents,
about
we
too
know
many
that's
redactions,
egregious.
not enough redactions. So,
That is unacceptable. It has been 6 months.
all right, your
and there's
time,
been
your time's
nothing
expired, and we want the documents. We've made that very clear. Chair recognizes Mr. Crane.
Can I do unanimous consent first?
Okay, before I recognize Mr. Crane, we'll let.
Thank you. I just want to do a unanimous consent request. This is actually an email that has been sent to your team, Mr. Comer, and our team from the Clinton lawyer and the Clintons that basically says, to be clear, we are not objecting to a transcript and never have. Please make that clear during today's testimony that was sent to you, Mr. Comer. So I just want to reemphasize they are not objecting to a transcript. Thank you.
And before I recognize Mr. Crane, let me reply. We just got that email, and we have spent 5 months trying to get acceptable terms that I think everyone within any sense of fairness would agree needs to occur. After we hold this vote, hopefully it'll be a bipartisan vote. They're going to have 2 weeks before this bill is on the floor. They're going to have 2 weeks before the full House votes on it. And make no mistake, to the Clintons and their lawyers, this bill will pass, and I believe it will pass with Democrat votes, even though I've heard Democrat leadership is whipping to try to get you all to vote no on this. They have had 5 months to comply with this, and to defend the indefensible and try to act like Bill Clinton's a victim here, I think is a stretch. We know who the victims are, and I think if you ask the victims, do you want to hear from Bill Clinton? I'm pretty confident I know what the answer will be, because our staff has communicated with their attorneys. Chair recognizes Mr. Crane.
Thank you, Mr. Chairman. Obviously, this committee hearing is about whether or not we're going to hold the Clintons in contempt of Congress. I strongly recommend that we do, especially in pertaining to the release of the Epstein files and trying to get to the bottom of what exactly went on there and how Jeffrey Epstein was allowed to continue doing what he was doing and abusing so many people for so long. It's interesting when I look at the history of the Congress and look at the fact that Peter Navarro, former Trump trade advisor, who defied the January 6th committee subpoena, was sent to prison for 4 months. Steve Bannon, also a former Trump advisor, defied the January 6th committee subpoena. He was sent to prison for 4 months, and several others. So it's going to be really telling to see how my Democrat colleagues vote on this one. Mr. Comer, how many times, Mr. Chairman, how many times did Mr. Epstein go to the White House in your recollection, sir?
According to the evidence that we've obtained, it appears he went 17 times during the Clinton presidency.
Is that more times than you've gone to the White House, Chairman?
I've been member of Congress for 9 years, and fairly high up on the pecking order. I've been to the White House, I believe, 9 times in 9 years. So he went to the Clinton White House double the number of times that I've been to the White House in my entire congressional career.
Mr. Chairman, how many times did Mr. Clinton fly on Mr. Epstein's plane?
At least 26 times, according to the flight logs that were subpoenaed from the estate.
Right.
Point of order, Mr. Chairman. Those were 4 different trips, 4 trips, and every time they regassed the plane, they counted that as another trip. But it was Asia, Africa, and they had to refuel. So every time they stopped to refuel, they counted that as another leg of the trip. There are 4 trips, not 27.
That's almost like I didn't inhale.
Reclaiming my time. That's still enough trips for us to want to be able to ask the Clintons questions about their involvement with Epstein. Is that true, Mr. Chairman?
Yes, sir.
Right. So, like I said, I hope that my Democrat colleagues who all of a sudden have found religion, this Congress, and now they want the Epstein files, even though over the last 4 years when they had control of Washington, D.C., you didn't hear a peep about Jeffrey Epstein out of any of them. And so I think it's going to be real telling, how my Democrat colleagues who claim to be all about the victims, how they actually vote on these contempt charges for the Clinton family. And I just think it's interesting, too, that, Mr. Chairman, my understanding is you've been working for the last 4 or 5 months to get the Clintons in here. Is that correct?
5 months, yes, sir.
Did they tell you that they would come in over December 24th and 25th, Christmas Eve and Christmas Day?
They have implied that they would come in, yes.
Okay, so that just goes to show that they're trying to dodge suggesting dates that they know none of us are in session. And I think that's pretty despicable. The other thing I believe that they said is that you and the ranking member could fly up to New York, but you couldn't record any of the conversations. Is that correct?
That is correct.
Does that sound like any congressional deposition you've ever heard of, sir?
No, and it would be my word against Mr. Garcia's, and I'm pretty confident I know whose side the New York Times would take, and the Washington Post would take, and MSNBC would take. And look, an investigation, you have to have transcripts, and the media wants transcripts. Well, you have to have transcripts. We don't do the notes. And the Clintons have already accused us of lying, and they accused us of saying this was an unlawful subpoena, which I appreciate Mr. Garcia admitting that it is a lawful subpoena. So I yield back.
I also want to point out one thing that I think has been pretty interesting. When I flew into Washington, D.C. yesterday, my chief of staff told me that he'd been contacted by the Clinton attorneys at least 3 times to try and stop this. So it looks as if they tried to resist you for about 5 months, and once we finally pulled the trigger on it, now they're realizing that this could go very poorly for them. Is that correct, Mr. Chairman?
That's how it appears, that they could stall, and then when it finally came to this vote, they felt like they could count on the Democrats objecting and a few of the Republicans that the media would go to, and the moderates, and say, oh, is this going to affect your election? Is this going to affect your election? At the end of the day, I think even the media wants to hear from Clinton. We all want to see the documents. So everyone in America that's keeping up with this, which is a majority of Americans, they want answers, and we're trying to get answers here today, and the Clintons have obstructed for 5 months. 5 months.
Thank you, Mr. Chairman. I yield back.
Chair recognizes Ms. Tlaib.
Sorry, thanks.
Oh, wait a minute. Ms. Randall, I'm sorry.
Thank you so much, Mr. Chair. I'd like to yield 30 seconds to the ranking member.
Thank you. I just want to again just clarify that that the Clintons have not objected to a transcript. I just want to clarify that, Mr. Comer, which you just mentioned, and I think that in this moment of negotiation, which you've been in and you've been in with them this entire time, there's progress being made, and they've not objected to the transcript. Let's talk to President Clinton, and let's get a transcript of it. Let's have the committee there and the staff there and move forward. Thank you.
If may I respond? We won't stop the talk. May I respond? They did object to a transcript, Mr. Garcia. They did object to a transcript. They're just now changing because they see that public opinion is not on their side. Chair recognizes Ms. Randall, and you've got. We'll give you 5 minutes. We'll give you 5 minutes.
Thank you so much, Mr. Chair. I want to start by saying I do not feel it is my responsibility to defend the former president of the United States. As a member of Congress in a separate and co-equal branch of government from the executive branch, and as a individual person who is responsible to my constituents, it is not my job to defend the former president of the United States. Just like it is not your responsibility, Chair Comer, to carry out the political retribution of the current president of the United States. It is also not this committee's job to yield to the Judiciary Committee to question the subjects of our subpoenas. It is not our job to defer to anyone else's interest. And in fact, we have the opportunity at any time to amend the rules of our committee should you choose to take action that our rules keep us from taking. Like that is a tool that you as committee chair and we as a committee have. And I also want to say, I'm not a lawyer. I'm a regular person. I'm 1 year into this job, and contrary to attempts by my Republican colleagues to put the burden of decisions made by Congresses of the past on our shoulders, I was sent here by my constituents just a year ago, and it's to them, to my neighbors, who I am accountable. Not to party leadership, not to anybody else, but to my constituents. So I want to talk about what they are seeing and hearing right now. They are seeing, just as Ms. Ansari previously said, Donald Trump and J.D. Vance and Pam Bondi switch allegiances, decide they no longer want to pursue accountability and full release, unredacted release of the Epstein files. But they're also seeing a system that has failed survivors and regular people over and over. That privileges the powerful and well-connected over regular people. Regular people who don't have the luxury of saying, I'm not going to come to court and I want to be free of any accountability. Regular people who see us acting and carrying out the demands of the president, former presidents, rich people, people who come to lobby us, folks who have access to power in a way that regular people don't. And I think we've all made very clear, all of us on both sides of this dais, that we want to hear from the former president of the United States about any information that he has related to Epstein's ring of trafficking and assault of women and girls. But we also, and Chair Comer, you have said over and over, that it's been 5 months that you've been in negotiations with the Clintons. It has been 6 months since this committee subpoenaed the Department of Justice for full release of the files. And I'm down to hold anybody accountable. I'm down for us to enforce our congressional subpoenas to uphold our power as a separate and co-equal branch of government. But I want to call the question, will my colleagues on the other side of this dais also hold accountable the Attorney General that has been illegally withholding evidence that has been subpoenaed by this committee and in a bipartisan law passed on the floor of the House? Is it just political theater? Are you just trying to point fingers and say, like, it's you, it's not us, it's them? Or are we here to do the work of holding accountable people who have committed heinous crimes against women and girls and people who might know about them? Are we doing that work, or are we just pointing fingers and trying to consolidate our own political power? That's a question I know that my constituents have, and it is one that I'm asking my colleagues on the other side of the dais. Thank you. I yield back.
Chair, any member seek recognition? Chair recognizes Ms. Tlaib from Michigan.
Mr. Chair, I think many of us were there with the survivors, and I'd like to bring them into the room because I think it's really important. You know, it's not just one president, but now two that have been connected to the Epstein sex trafficking. One of them even testified about walking into the house, the butler opening the door, there's administrative assistant, having no idea she was walking into a horrific scheme that was sending young girls to the powerful, to the rich, the elected officials. And one of the first pictures she said she saw was of Clinton with his arms around Epstein. She saw another one of Trump with Epstein. And I just remember her almost trying to convince us, like, understand that I had no idea, as if somehow she was guilty. Do you all remember that? Yeah. And so I'm here to tell you, I'm ready to vote, but I'm also just taken aback and disgusted because I didn't need a birthday card to say the President of the United States, current President of the United States, had something. I didn't need to see the photos by the chairman today of Clinton. All I needed to do was hear the survivors tell us, please do something. These are people that have impacted their lives forever. What I just don't understand, Mr. Chair, and this is with all due respect, I just don't get why Bondi cannot be held in contempt, why we're not for it. I don't care if she says that she wants to plead the fifth. So what? Do it in front of the American people. Same thing with Maxwell. She's telling the committee she's going to plead the fifth. Fine. Have her come before this committee to do it in front of the American people. The fact of the matter is, are you saying that if anybody wants to plead the fifth, they don't have to be forced to come before this committee? That doesn't make any sense. What excuse is that? That doesn't make any sense. The fact that I continue to tell you all, what is the most consistent thing survivors have asked us to do? Follow the money. How come we haven't forced JP Morgan Chase before this committee? How come we haven't allowed Bank of America to come before this committee? Mr. Chair, it is so disgusting. And this is why everybody's so distracted by this whole thing of like, oh, you know, the Clintons, Trump and everything. But who was funding it? Literally, JP Morgan turned a blind eye to evidence of sex trafficking even after his 2008 conviction. Hear me out. After he was convicted, they still hid suspicious activity reports that should have been reported. You know, you see the fact that continuing them saying, well, in 2028, agreed to pay what, $290 million to settle a lawsuit. I don't care. You come here, and because it's the truth, y'all. You guys got to realize Epstein's not the last person. There's probably another Epstein out there right now doing sex trafficking right now. We should hold everybody in contempt that had anything to do to cover this up, including bank executives that still have their jobs. The fact of the matter is, we know what this is. You want to talk about Bill Clinton, Hillary Clinton, but talk about everybody involved. Because it does look like you're only doing this to distract everyone when we know not one, but two presidents were involved. And those young ladies shaking when they were testing for because they didn't know if they could trust us. Some of them literally said, we had no idea what we were walking into. But they were connected to the rich. They were connected to the presidents. You heard them say that over and over again. But one of the things they continue to say is follow the money. Because, Mr. Chair, Bill Clinton, Donald Trump, J.P. Morgan, all these people, they will not be the last folks that allowed a sex trafficker to harm young women, children. And so we have to set a very good precedent that we will not sit back and say, well, Maxwell's going to plead the fifth, Bondi's going to plead the fifth. I don't care. You're a public servant. Come before this committee. Maxwell, you were directly involved. How many times did the survivors mention her? How many times? Saying that she lured them in. She was primarily involved. And Mr. Chair, you and I had conversations. And you said, give us names. They gave us names. And you know it. So why y'all focused only on them? And let me tell you, you know where I stand. I will hold anybody in contempt that will not give us information. I don't care how many lawyers they bounce up on us. But I'll tell you, Mr. Chair, shame on us for not forcing Bondi before this committee. Shame on us for not forcing Maxwell before this committee. Shame on us for not forcing J.P. Morgan Chase to answer questions that many of us have of $1.5 billion in suspicious activity. Because somebody had to fund this madness, this horrific actions by these men. With that, Mr. Chair, I yield.
Ms. Tlaib, if I may respond to some of that before I recognize Ms. Bobert's next. Okay. I believe with all my heart you are as sincere as anyone on this committee about wanting to get answers about the truth. And I believe your heart is pure. Maxwell is coming in front of this committee. And
but
we've
when?
tried.
No, let us decide that today. When? Like
Well,
when?
it's nailed down. February what day? The 9th. She's
February
coming,
9th.
and you'll be able to ask her questions. That's one of the things Clinton wanted was only me and Garcia. Maxwell's coming. Anyone who wants to ask her questions on this committee will be able to. So that's.
No, I think
that's
the American
nailed down.
people want answers from President Clinton.
I'm not trying to argue with you, Ms. Lee. I just want to respond to. Pam Bondi is coming before Congress in 2 weeks. I am confident she is going to be grilled by both parties on the discharge petition. If you didn't want, I don't want to, and Ms. Randall, you mentioned something about the Judiciary Committee. Believe me, I don't want to work with the Judiciary Committee on any investigation, okay? But when we passed that discharge petition, that got them involved.
But we had an outstanding subpoena.
Just let me explain. Pam Bondi's going to be in front of the Judiciary Committee. We'll see how that goes. We'll see if there's been a document dumped.
Mr. Chair, we can't
after that.
forget the banking institutions either.
The last thing, this is the most important thing. Months ago, I approached Ms. Tlaib, Ms. Lee, and Ms. Stansbury, and I said, please, if you all get a chance, and I know you all are all sincere, try to get some names from these women, and we will continue to try to get documents.
Mr. Chair,
If I didn't
Mr.
want
Chair,
to know
let's
that,
follow
if we
the
didn't
money.
want to,
Let's
Ms.
bring these bank
Ms. Tlaib, you're out of
executives.
order. I'm just we want to hold everyone accountable. We don't care. We don't care if they're billionaires. We don't care if they're Republicans. We don't care who they are.
Do you agree to work with me, though? We got to get the bank executives being funded in some other way. Epstein's dead. But we know there's another person out there doing the same thing. We know it because the banks covered up. These suspicious activity forms were literally these reports that had to be filed. They were there for a reason. So we can stop.
And last thing, and then I'm going to open it, I think, to see if there's any other members. But we are going in looking at suspicious activity reports, both Republicans and Democrat staffs going in looking at suspicious activity reports as we speak. I'm all about looking at suspicious activity reports. Now, time's expired. Does any other member seek recognition? Mr. Fallon from Texas.
No one is above the law, and no one should be escaping accountability. And Hillary Clinton said that. And according to the LA Times, there's another quote. I agree with both of these quotes. Al Gore said that when he was a member of this chamber, Bill Clinton's own vice president. I hope every member of this committee agrees with those quotes. So we have to ask ourselves, are we a rule of law nation? Or are we not? When a citizen of these United States is subpoenaed by this Congress, they should comply, plain and simple, regardless of who they are. We all get accused of things, and we should do everything we can to, because Jeffrey Epstein was a rapist, pedophile, sex trafficker. In street parlance, he was a scumbag, lowlife, and slimeball. And some of the things that I've read in these files, he was evil incarnate. He's also dead. I didn't even know who he was until he wasn't. So why are we here talking about a dead guy? Because he was associated with powerful people with him in some of the worst kind of criminal activity. And if they did, they should pay. They should face justice. Whether they're rich or poor, famous or anonymous, mighty or meek. So is that what we're doing today? Are we pursuing justice and transparency? Because transparency makes an easier and shorter path to the truth. We should be pursuing the truth. But some on this committee and in this Congress, and exploiting this issue, not in the pursuit of justice, but in the pursuit of raising hundreds of thousands of dollars using a false premise as a battering ram. Jeffrey Epstein, and here's the false premise, that Epstein was a creature of the political right, and they're protecting him, and he was pounding around with Donald Trump, and those in his Republicans won't release the files. Now that's incendiary, but is it true? Or is it just a cheap woke? Under Bill Clinton, there were 17. Jeffrey Epstein visited the Clinton White House 17 times. How many times did he visit the Donald Trump White House? 0. How about documented non-Clinton political contributions? 118,000 to the Dems, 18,000 to the GOP, for a total of 89% to the Dems, 18,000 to the GOP, for a total of 89% to the Democrats and the Clintons, 11% to the GOP. Now to the matter at hand. Epstein files released by the oversight Democrats from 2019 to 2023 when they were in charge of this committee. 0. Epstein released files by the oversight Republicans from 2023 to present. 53,000 in the 4 years he was in office. Again, 0. Epstein files released by the Trump DOJ 2025 to present. 125,000 pages. And a member of this committee completely jumped the shark again. And right after Charlie Kirk was assassinated by a left, down the temperature and practiced some civility, said, and I quote, "Republicans have been so busy protecting pedophiles and rapists that they forgot what this committee is supposed to be about." Well, I tell you what this committee is supposed to be about, Mr. Chairman, about transparency and truth. And on this matter, the Republicans have led. And we produced results. And the Democrats have done squat and bumpkiss. For the record, you know, that kind of incendiary rhetoric, while it may make headlines and make people famous, or perhaps better stated infamous, and raise loads of woke cash, maybe even get you invited to Hollywood parties. But at what cost? Those kind of lies create division and damage, and they're ludicrous, absurd, lazy, and perhaps, worst of all, unoriginal. And I don't think it's going to translate much to Journey to the Upper Chamber. I hope it doesn't translate to that. The Trump administration and Republicans on this committee and on this issue have served Lady Justice by a count of about 178,000 to 0. So the Clintons should come in, honor the subpoena, and testify. And you know why, Mr. Chairman? In the pursuit of truth. Mr. Chairman, I yield back. In the pursuit of truth. Mr. Chairman, I yield back.
Gentleman yields back. Chair recognizes Ms. Stansberry from New Mexico.
Thank you, Mr. Chairman. You'll have to forgive me if I do not give a slow clap to our colleague across the aisle for his Academy Award-winning appearance just now in front of the committee. But I want to just address some of the things that I heard here today and to talk about why we're here. What I've heard here this morning in front of this committee is exactly why the American people hate politics. Because the American people don't care if you're a Republican, if you're a Democrat, if you're an independent, whether you vote or you don't. They want the Epstein files and they want justice and accountability. And they don't give a damn whether or not it's Democrats or Republicans or who is implicated. They want accountability. And that is what the survivors are asking us for. They are asking us to do our jobs, to make good on the promises that we made them when they came and met with us, and to actually, in good faith, conduct an investigation. Now, I always think it's important to pull back the curtain for the American people about what happens in these committees. And I was not shocked and surprised, but, you know, I think it's important to note that when I stepped out of the committee a few moments ago, the press were huddled on the Republican side of this committee room to take statements from the Republicans. They're not out in the kind of like neutral area. They're standing outside the Republican door so that after this vote is taken, our Republican colleagues can walk out and make a statement to the press. Now, I think that that's important to note for the public here, because this is not about true accountability. Because if this was actually about getting to the bottom of this case and actually holding individuals accountable for the crimes that were committed by Jeffrey Epstein, by Ghislaine Maxwell, by the associates, and the many, many people who are implicated in this case, what would be happening right now in this committee is that Pam Bondi and DOJ officials would be sitting right there on the witness panel answering questions under oath, because they are breaking the law. They are not complying with our subpoena. They are not complying with the Epstein Transparency Act. And on the day, the final deadline, that they were supposed to release their final explanation about why they may have redacted some files, and in fact they have, as has been stated many times, only released less than 1% of the files, Donald Trump used the United States military to invade a foreign country and steal their oil. And while we're sitting here and our colleagues are trying to create a spectacle for the media, every single newspaper in the United States and the world's headline is about how Donald Trump right now is in Europe embarrassing the United States. How he is threatening our NATO allies to invade Greenland. Humiliating the United States. And I have to say, I was home over the weekend for Dr. Martin Luther King Jr. celebrations to honor the life and legacy of Dr. King. And the question that I got over and over again from my constituents is, what is in those files that is so bad that President Trump is invading Venezuela, threatening our NATO allies, and sending thousands of armed paramilitary troops onto our streets to create violence and chaos in American cities? That is what the American people are actually asking us. And so I will be honest, Mr. Chairman, I am deeply troubled that the individuals who are the subject of today's hearing did not appear on their scheduled date. No one is above the law. But I do know, based on the correspondence, that they have been corresponding with you regularly to try to resolve this issue. But I don't believe that's what this hearing is actually about. Because if it was actually about getting justice and about getting the truth, we would have DOJ here. We would be holding Pam Bondi in contempt, and we would be hearing from the survivors themselves. And so I have to agree with my colleagues that I believe that this is part of an extended smokescreen to try to cover things up. And so I do ask my colleagues across the aisle, if you are earnest about getting to the truth and getting to justice, then bring DOJ in here and hold them accountable, because that is actually what the American people want. I yield back.
And lady yields back. Before I recognize Mr. Biggs, I want to point out again for the umpteenth time, Pam Bondi is coming in front of Congress under oath, and there'll be lots of opportunities to ask her questions about the Epstein files.
Mr. Chair, can I ask a question?
She's violated a subpoena from this committee, and she should be held in contempt for that. That's a fact.
Here's the difference. They have been turning over documents. Now, I've said it 100 times. It's not as quick as we would like, but they're turning over documents. And I've been very clear today and in hundreds of interviews.
You can't be serious that one person is turning over documents. What's the deadline for them? When do you expect the full document?
In our subpoena, there was no deadline. And then we voted for the discharge petition, and there's a deadline. The discharge petition's in judiciary. She's coming in front of judiciary. Now, that's
That's
That is a
irrelevant to
fact.
this
Don't try to
investigation from the Oversight Committee.
Bill Clinton's not a victim here, and the media is not going
I do not
to
think
take
Bill
Republican
Clinton is a
side on
victim,
anything.
but I don't
So
think
let's
Pam
just
Bondi's a
be
victim.
right.
I think Pam Bondi
Chair
is
recognizes
the one
Mr.
covering
Biggs.
this up.
It's Mr. Biggs, 5 minutes.
Thank you, Mr. Chairman. And I would just point out, the previous speaker was talking about peeling back so the public can see what goes on in a committee. I mean, I just came from another committee where we were talking about massive fraud around the country and in particular in Minnesota. And I'm glad that 2 Democrats could find time out of their busy schedule to even attend that hearing. What a shame. What a shame. So when someone says, what is in the files is so bad, I'll ask this question. What is in the files that's so bad that the Democrats for 4 years, for 4 years when they had control of this committee, didn't release a single document, didn't call a single witness, didn't make any motion. In fact, for those 4 years, go back and look. Did they ever say anything about Epstein? No, they didn't. But wanting to make a press, wanting to get it on the press, that's why you're making the issue today. Because let's talk about why we need to talk with, do this contempt is because former President Clinton and former Secretary of State Hillary Clinton basically strung us along as we were bending over backwards trying to accommodate their schedule. They didn't show up after we finally had to get a subpoena for them. And I have right here, this is just interesting to me. This is a little note written by Mr. Clinton, former President Clinton, to Jeffrey Epstein's 50th birthday. Jeffrey, happy 50th. It's reassuring, isn't it, to have lasted as long across all the years of learning and knowing, adventures and, no illegible word, and also to have your childlike curiosity, the drive to make a difference, and the solace of friends. He rode on that plane many times. He was apparently close friends with him. Jeffrey Epstein claims that, and I don't know if we should believe anything Epstein says for sure, but I mean, Epstein says that he helped set up and fund the Clinton Foundation, and former President Clinton in his note, I mean, this is what he wants. He doesn't want to come in and testify. He wants to do the same thing that he did in previous times. Just, okay, we're going to send a little note, that ought to do it. He says something to the effect that he spent significant time in the Clinton Foundation after he left the presidency. Well, if Jeffrey Epstein set it up, then there's some reason to ask questions of both he and the former Secretary of State. They were given a subpoena. It was a lawfully issued subpoena by a standing committee. By the way, I happened to be at that subcommittee hearing. I was there when every Democrat voice voted that out. Nobody objected and said they didn't want him to be subpoenaed. But he was subpoenaed, and he didn't show up. So here we are. And with Mr. Chairman, I'll yield time to you if you need it.
I appreciate it. I think that everything that needs to be pointed out, we've pointed out. So I will.
Then I'll yield, sir.
Okay. Chair, any other members seek recognition?
Chairman.
Mr. Mfume.
Thank you, Mr. Chairman. I want to thank you and the ranking member, and I particularly want to underscore the ranking member's opening statement, and that was that oversight Democrats want the truth about Jeffrey Epstein's crimes and accountability for everyone involved. He said, and I agree, we want transparency, we want the facts, and above all, we want this committee to use its oversight tools in a serious and responsible way. I would be remiss if I did not thank on behalf of all of us the efforts of Representative Rokana of this committee and Representative Massey. Thank God they stood in the way of things and took the heat to get the discharge petition up and voted on. And I want to also point out something that I think is important, and that is consistencies, Mr. Chairman. The action that the majority has been proposing today departs from this committee's established practices, including its long-time standing acceptance of written testimony and the level of accommodation this committee has traditionally required before proceeding to criminal contempt, not civil, criminal contempt. I'm glad, as the ranking member has stated, that the Clintons have agreed to testimony and to a transcript and to meet. I agree also that that meeting should not be taking place in New York. It sends the wrong reason for anybody that gets something from this committee. They should come to the committee. It's just that plain and simple. But it departs in many instances with the way this committee has moved on. And I say that because we never know this time next year who might hold that gavel and who on either side may want to go after the current president, his sons, his wife, his family, and anybody connected to him as a department head. I'm just pointing out the fact that it's a slippery slope. Now, does Bill Clinton have to defend himself? Absolutely, yes. It is a bit curious, however, why we are going after Mrs. Clinton. I've not seen anything, as the gentleman from Massachusetts said earlier, that suggests that she ought to be a part of this in any way or has done something wrong or is complicit in this matter. And I would hope that there's some consideration, Mr. Chairman, to withdrawing at the very least that particular resolution. It just makes me think that this is a fishing expedition and that we want to dust her up a bit if we get her before this committee. Now, a couple of quick things. We're being asked to move forward holding a former president of the United States, again, not in civil contempt, in criminal contempt of Congress. And I'm going to tell you why it's an extraordinary step. Not that it's unprecedented, it's extraordinary, but it is unprecedented in the fact that we did not do that with Richard Nixon, we did not do that with Donald Trump. There was a subpoena, but there was never an attempt to find them in criminal contempt of the Congress or of this committee. It's an extraordinary remedy that's usually reserved for situations where a witness has clearly and willfully defied Congress after extraordinary processes have been exhausted. The majority has not demonstrated that standard so far. I do want to say also that we're in a situation where I don't think that anybody on the Republican or on the Democratic side of this committee is trying to defend former President Clinton. They're trying to find a way to make sure that we're consistent. So the reason we keep hearing the need to have Pam Bondi before this committee is that we're getting ready to bring criminal contempt charges before there's been an investigation. Usually that happens after the investigation. And the notion that somebody is going to come before this committee, Mrs. Maxwell, and take the fifth, I don't care. She's already a convicted criminal. She can't take the fifth. But we can do the actions we ought to be about, and that is to make sure that both of them are before this committee, and then to make sure also, or to suggest, it's up to you and the ranking member, that that meeting takes place and those transcripts are made available, and that Mr. Clinton comes before the committee with counsel so that we then are in a position to move forward. We're taking a big jump here without doing some of the things that we normally do. Now, I'm glad that Ms. Tlaib brought up the matter of victims. She's not here right now, but all of us sat in that room with those victims. It was gut-wrenching, and all of us made a commitment that we would prove that this institution could and would do the right thing. So we're challenged here, Mr. Chairman, and I hope that you and the ranking member can give us a way to proceed here, that both of the concerns on both sides are addressed. But if we just move straight as we're going now without an investigation, it begs the question, what happens when the shoe is on the other foot? I yield back.
Gentleman yields back. Ms. Simons next. Before I recognize her, I just want to add, with respect to the Hillary Clinton subpoena, you all voted for that. This committee voted for that in a bipartisan manner. Her name was on that list. And with respect to Pam Bondi, again, she's testifying in front of Congress in less than 2 weeks. Chair recognizes Ms. Simon.
Thank you, Mr. Chairman. Just a quick comment, and I have a friendly question for my colleague, Ms. Luna. And I'll say a friendly question. I've worked with victims for decades. So few opportunities present themselves for victims to sit face to face with folks who hold power, to beg and plead that everyone who had anything to do with their harm be held to account. So few opportunities. I have been a victim advocate where brilliant young women who have been trafficked across this country have stood in courtrooms and were demanded to testify against their traffickers, and they did with such power and grace in fear that their lives may be taken because of that braveness. And a number of those young women that I witnessed take all that they had to confront their demons, they were murdered because they took a stand. And so when we did stand in front and sit in front of those victims and they gave us their all, I hope that this is not the only opportunity, Mr. Chair, to speak on their behalf. From our president to everyone in those files, forget all the political games. If these women who are connected with the largest sex trafficking ring in modern day American history cannot get justice, what about the girls in every single state? I mean, it is what it is. That being said, Ms. Luna, you talked briefly about a proposal.
She's not in.
She's out.
That's both.
There was a proposal put on the table to rethink how we might have a conversation about the Clintons or President Clinton coming in and having a conversation with this body. And I guess that time has passed, but I know that I would love to hear from the former president of the United States. I would love to hear from the Attorney General. I would love to hear from the current president of these United States. The victims deserve to be heard. The victims deserve for the files to be released in their entirety. And the victims deserve for us to get to the bottom of this matter. I yield back. Well, I actually would like to yield my time to the ranking member.
Actually, I'm okay right now on time. I might come back around, but back to Mr. Comer and the Republicans. Thank you, Ms. Simon.
Okay. Do any other members seek recognition? Seeing none, we are going to, there's an amendment at the desk. Well, let's Ms. Lee, what purpose do you seek recognition?
I have an amendment at the desk.
Will the clerk distribute the amendment to all members? The clerk will designate the amendment.
An amendment to the amendment in nature of a substitute to the William J. Clinton contempt report as offered by Ms. Lee of Pennsylvania.
Without objection, the amendment is considered as read. I reserve a point of order. The gentlewoman is recognized for 5 minutes to explain her amendment.
Thank you, Mr. Chair. I think that even listening to this debate throughout our hearing today, our markup today, I think it's really clear that at the heart of this effort to release the Epstein files are very real human beings who have experienced unimaginable harm. They have been repeatedly victimized by the indifference of the U.S. government and the injustice that they face. They deserve peace and healing and justice. When my motion to subpoena the Epstein files passed, this committee resolved to get that justice for those survivors. And I thank Chairman Comer for pushing this effort forward by issuing additional subpoenas for the Epstein estate and the banks. And we know that without the full files from the DOJ, that is just not enough. That's why I'm introducing this amendment, which holds Attorney General Pam Bondi in civil contempt for failing to comply with the August 5th subpoena, and I urge my colleagues to support it. And we believe that we should start with civil contempt because we are serious about this investigation. We want these files and we want to hear from them. And we must start there. The Department of Justice needs to be the priority. We can move to non-compliance by anyone else, including Ghislaine Maxwell, after we have received those files. It has been 5 months, and we're still missing over 5 million pages of documents purportedly. The Department of Justice has only released 1% of those files. They have stonewalled this committee since August, and they have failed to provide even the most basic updates. How is that not an insult both to the authority of this committee and the survivors? Without the full files, how can we know who might have legitimate knowledge or who might be culpable? We wouldn't have to speculate on the Clintons or anyone else's involvement if we had all of those files. And to be clear, I'm certainly not opposed to the President and Secretary Clinton being held accountable for violating the subpoena. But the fact that this effort to hold the Clintons in contempt was fast-tracked and is happening before any action against the Justice Department is just evidence that the Republicans on this committee are not taking this investigation seriously. It is an unequal application of law. And again, it is a bit ironic that these contempt resolutions empower the Justice Department to imprison possibly 2 people for defying the exact same subpoena that they themselves are defying. If this committee wants to be taken seriously, we would be addressing all the bad actors in this investigation, not cherry picking them for political points. The Justice Department needs to be held accountable for their non-compliance and lack of transparency. They have been selectively producing information, shielding powerful people, and obstructing any efforts for oversight. And if we don't hold them accountable, Mr. Chair, we are too. Just this past Friday, Attorney General Bondi asked a New York federal judge to deny an appointment of a special master to monitor the release of the Epstein files. They don't want a neutral third party making sure they follow the law. I think all of us should be questioning what the Justice Department is doing that they don't want the American people to see. We can't just take them at their word that they'll eventually get around to releasing the files. Quite frankly, they have put up the same, if not far less of an action as the Clintons have. What little information they've released so far has either already been made public or has been a mess of just sketchy redactions. A group of survivors sent a letter to the Justice Department's Inspector General complaining that the redactions had been, quote, selective. They pointed out that multiple times the names of alleged abusers appeared to be redacted, yet some survivors' names and identifying information were released. To be clear, the subpoena I moved to secure does not allow for redactions unless it would protect the identity of a survivor or contains child sex abuse materials. They have had plenty of time to work with this committee to protect survivors' identities. This is bigger than one case. It's about rich and powerful people being protected by each other and institutions. It's about a system that has enabled Jeffrey Epstein and Ghislaine Maxwell and whoever their co-conspirators are to buy favors and silence from our government. This effort is the one time we could get some real accountability and reclaim the power of this system. Republicans, don't drop the ball by allowing Pam Bondi and the Department of Justice to play us for fools. Mr. Chair, you are setting a precedent that non-compliance with this committee will result in immediate contempt proceedings. So I challenge you and my Republican colleagues to put your money where your mouth is and pass this amendment and holding Pam Bondi in contempt. I yield back.
Gentle yields back. I'll recognize myself just for amendment. Look, I oppose this amendment, and I hope everyone on the committee opposes this. That's because Attorney General Bondi and the Department of Justice, they have released documents. Again, not at the speed or pace that any of us want, but they are complying with our subpoena. That is a fact. I oppose your amendment, Ms. Lee, because you amend the criminal to civil. And I think that most of what I'm hearing from my colleagues on the other side of the aisle is everyone wants to hear from the Clintons. They've had an opportunity for 5 months. They will have another opportunity between today's vote and the floor to come in and answer questions. Pam Bondi is coming in front of Congress in less than 2 weeks to answer questions. Your colleague, Ms. Crockett, I don't want to speak for Ms. Crockett, but I'm pretty confident Ms. Crockett's going to grill Pam Bondi, right? You agree with me? I would have won that bet. Well, we'll see. I think that's a good. She may. I hope she does. So I oppose this. Now, Chair recognizes Mr. Garcia.
Thank you, Mr. Chairman. I want to just start by saying I strongly support the amendment proposed by Congresswoman Lee. The House majority keeps saying that they believe that no one is above the law. Oversight Democrats certainly believe that. But the Attorney General is violating it with impunity in support of a White House cover-up every single day. We want accountability for her failure to comply with our subpoena for the full Epstein files that's been in place since the summer. She fails to comply with the Epstein Files Transparency Act. She fails to comply with the subpoena put in place by Representative Lee and the committee. This is clearly a White House-directed cover-up. Now, over a month after the deadline, only 1% of these files have been released. No explanation has been given for illegal redactions, again in violation of the law. Epstein survivors have reported that their names have appeared in parts of the document that were not redacted. And every day, she continues to withhold files and conceals the truth. She continues to give Ghislaine Maxwell special treatment by moving her to a less secure prison that we all are aware, which is completely shameful. Now, Chairman Comer, you claim, of course, that the Attorney General was complying with our subpoena. I mean, that is absolutely false. 1% of the documents since a subpoena in place during the summer is not complying with our subpoena. Now, on August 5th, 2025, this committee issued that subpoena, compelling her to produce documents and communications. That subpoena unambiguously required the Attorney General to do that no later than August 19th of 2025. August 19th, not December, August 19th of 2025. On August 22nd, the DOJ made a single production of approximately 33,000 pages to this committee. All of those documents, however, were already public. The DOJ has made no additional productions to the committee pursuant to the subpoena. The DOJ has failed to provide specific information in response to repeated requests from Democratic oversight staff as to why the DOJ's timetable continues to move and why it's not fulfilled its production or the law. Now, in response to letters from our committee on November 25th, the DOJ transmitted a single letter in response to the committee's inquiries. They claimed that the DOJ was working to comply with the Epstein Files Transparency Act, which now, of course, we know they actually weren't doing because we actually haven't received very much. The letter made no reference to the committee's subpoena, no reference to DOJ's plan for compliance. The corrupt failure to comply with the Epstein Files Transparency Act is not just a crime, it also shows that the Attorney General has made no attempt.
More than half the committee, they were demanding that we subpoena the estate, and we did. We got every document from the estate. There were people who said, oh, there are going to be a lot of questions answered. There'll be names and all. We've subpoenaed every document, every picture, everything from the estate. We never held back. We've been serious. We've all supported the full release of the documents. As I've stated many times publicly, we wish the process was going quicker. That's a lot of documents, a lot of redactions, a lot of eyes have to be put on this. So the Department of Justice is complying. Now, with respect to Maxwell and the Clintons are not treated differently. Maxwell was always, she was willing to appear, but made very clear she would take the Fifth Amendment. The Clintons refused to appear. The Clintons refused to appear. And one of the proposals that Clinton made was if we would let Hillary Clinton off, then Mr. Garcia and I could travel to Mr. Clinton's house and bring one staffer and take notes, but no transcript. That's not even a thing. And you all know that. The media, I'm sure, would require a transcript. There's no real investigation without a transcript. So, what few counter proposals the Clintons' massive legal team has made aren't acceptable. And I don't think anyone is going to stand up here and willing to publicly argue that they were. So does any other member seek recognition? Mr. Frost.
Thank you, Mr. Chairman. The American people deserve full transparency, and anyone who has relevant information about Jeffrey Epstein's crimes must be compelled to come forward and share with this committee. Wealth and power cannot shield people from accountability from this committee. It is the victims of these horrific crimes who deserve protection, not Jeffrey Epstein and the people associated with him. We all agree. We want to hear from former President Bill Clinton. But committee Republicans have failed to conduct a serious investigation. For instance, they refused to hold Attorney General Pam Bondi in contempt for failure to release 99% of the Epstein files on a bipartisan law that we all passed on the House floor, and B, that had a deadline. And B, they refused to hold Ghislaine Maxwell accountable for defying this committee's subpoenas. We all know that President Trump has a long-standing relationship with Jeffrey Epstein. His administration continues to obstruct the release of the Epstein files for this reason. We've seen photos of them together. Even Elon Musk posted, @Real Donald Trump is in the Epstein files. That's the real reason why they have not been made public. President Trump's own Mar-a-Lago club appears to come up often in connection to Jeffrey Epstein. From reporting, we know that Epstein was deeply involved with Mar-a-Lago. He was a frequent visitor to the club for years. The club sent employees, usually young women, to Epstein's mansion for massages, manicures, and other spa services. Staff members from the club made frequent calls to Epstein's home in Palm Beach, and on these calls, Epstein engaged in sexually suggestive behavior, such as exposing himself. And in 2000, Ghislaine Maxwell recruited Epstein's trafficking victim from Mar-a-Lago, where she was working as an employee. This committee must also investigate what Mar-a-Lago club members and the staff knew about Jeffrey Epstein's crimes. Getting documents from Mar-a-Lago is about uncovering evidence, holding these people accountable, and doing right by the victims of these horrific crimes. So we are all for making sure that we hear from everyone. I don't care if you're a Democrat, I don't care if you're a Republican. I'm tired of rich people trying to evade justice and accountability, period. But you can't do it just for the party you disagree with. You can't do it in a politically motivated way. So here's the opportunity to show it's not a politically motivated thing. Let's also make sure that we get these documents from Mar-a-Lago. So with that, pursuant to Clause 2K6 of House Rule 11, I move that the House shall subpoena the Mar-a-Lago Club and all entities under common ownership or control with the Mar-a-Lago Club to provide the House Committee on Oversight and Government Reform with 1. All documents, communications, and materials related to Jeffrey Epstein, to include but not limited to personnel files and records, client files and records, massage and spa services records, complaints and grievances filed against Jeffrey Epstein, internal communications, and billing statements. 2. A list of all Mar-a-Lago Club personnel who provided massages on behalf of the Mar-a-Lago Club between 1997 and 2003, regardless of whether such personnel were contractors or formerly employed masseuses or otherwise. And 3, a list of all Mar-a-Lago Club personnel who were employed as or acted as managers of the Mar-a-Lago Club Spa between 1997 and 2003.
A motion was made by Mr. Frost. The motion is improper as the item is not on the agenda. Any other chair recognizes?
So Mr. Chair, you want to use procedure to push back accountability?
No, we're holding people accountable today. That's why we're here.
Well, why won't you move to make sure that we get the relevant documents from Mar-a-Lago? That I just read this, and you're saying it's because it's not on the agenda that we can't move forward with this? You have full discretion of this committee to say, you know what, let's have a vote in a bipartisan way to say we want the documents from Mar-a-Lago.
I don't have full discretion. It's in the rules. We vote on a rules package at the beginning of
You're able
Congress.
to say right now that we can vote on this.
We cannot vote on it. It's in our rules. We'll be breaking our rules. We have to apply to the rules too. We're not like the Clintons.
No. You are hiding behind process to protect these Mar-a-Lago documents, and I think it's disgraceful.
Chair recognizes Mr. Cloud.
Thank you, Mr. Chairman. One thing was noted in the Clintons' letters is they said the subpoenas were illegal. I'd be curious to know if the ranking member thinks that they're illegal. And with that, I'd yield the rest of my time to you.
Thank you, Mr. Cloud. I want to make sure everyone is aware. On February 11th, Attorney General Bondi will be appearing as the sole witness in front of the Judiciary Committee. Ms. Crockett is a member of the Judiciary Committee. I would assume, I don't want to speak for Ms. Crockett, but I would assume you'll ask her questions about the Epstein investigation and her progress towards releasing the documents. Mr. Massey is a member of the Judiciary Committee. He's already stated publicly he's going to spend his 5 minutes asking the Attorney General about the Epstein documents. So the Attorney General is slated to be in front of Congress, and I'm pretty confident that just about everybody on that committee is going to ask the Attorney General where we are with the document production. So I think that's important to note. February 11th, she's slated to be in front of the Judiciary Committee, and with the discharge petition, when the House voted for that, we issued the subpoenas for the Epstein documents. Then we all voted for the discharge petition. The discharge petition has jurisdiction in the Judiciary Committee. So she's going to be in front of the Judiciary Committee. The next week we're in session. So I think that's important to note. Do any other members seek? Okay, Mr. Lynch, then, yeah, go ahead.
Thank you, Mr. Chairman. I would remind the gentleman, and I'm sure he knows this, that the Oversight Committee is the principal investigatory committee in the House. And we have a responsibility. It may be a shared responsibility with Judiciary, but we nevertheless have a responsibility. And we are the ones who issued that subpoena. This committee did. We are the ones who sat with the victims, right? We looked them in the eye, including the Speaker of the House. We looked them in the eye, these women who have been struggling to get justice for many, many years, and we promised them, every member of this committee, we promised them that we would do everything under our power to make sure they finally receive justice. And here we are today. Now, with millions and millions of documents requested back in August, we've still received, 1% of the documents? This is evidence of wrongdoing in many cases. And yet we're allowing Attorney General Bondi to obstruct justice, basically. Even the little bit of evidence that she has provided, she also included a statement that basically said, don't believe this evidence, there's a lot of falsity in these. I mean, I have never seen an Attorney General in this country provide evidence and then give an opinion on that evidence to the legislature, to the Congress. That is unheard of. But it shows her willingness to do whatever she can to obstruct justice from being delivered. The second thing I want to say is, if we are truly interested in getting information relative to this investigation, there should be some underlying basis for that. And I have reviewed all of the evidence that's been made available so far. I find nothing that points to Secretary Clinton in this at all. Yes, she was Secretary of State at one point, but the information that we're trying to get with respect to Secretary of State is available from any Secretary of State that served in that office with respect to trafficking. So there is no direct reason, no direct evidence to point to Secretary Clinton in any of this. And yet, while those millions of documents are being denied us, we're pulling someone forward, I think, for the point of embarrassment, public embarrassment, and because of ill will on the part of the president, to bring her forward for embarrassment, but not for the purpose of gaining helpful information for this investigation. Mr. Chairman, I'll yield the balance of my time to the ranking member, Mr. Garcia.
Thank you, Congressman Lynch. Mr. Comer, I just want to be pretty clear about two things, and one particularly something that you said. Let me just start by saying that you noted in your comments that your concern and your biggest concern was the issue of the transcript. And I want to just go back really quick, because you and I share respect for subpoenas. Mm-hmm. You and I share that we want the former president to answer questions. Is that correct?
Correct.
Great. And so does every other member of this committee. We want the former president to answer questions of this committee. And we want not just the former president, but everyone to follow subpoenas of this committee. So let's agree on that. But to be clear, President Clinton the former president, has submitted a signed declaration. He's offered to sit with you and me and answer questions. He's offered to have staff in the room to transcribe and be there while those questions are being answered. And his request was to do it in a dignified way. Your concern, as you brought up in your last comments, was that he was unwilling to do a recorded transcript. That's actually also not true. And to be clear, there's been public reporting, including in articles that came out over the weekend, that they have not ruled out a recorded transcript. I want to ask the president questions. Chairman Comer, I want to ask President Clinton questions. Don't you?
That's why we're here.
I want to ask President Clinton questions and a recorded transcript and with our members of our staff. Would you like to do that also?
May I make a comment on the transcript? They have not agreed to a transcript. Staff notes are not equivalent.
They've actually made public reporting.
So they're wanting me to make note. They said, okay, Comer can take notes, but they've called us all liars, and you know how the Clintons have gone on offense, and look, they don't get to make the rules. We make the rules.
Can I have the rest of my time back?
Yeah.
Okay, thank you. I want to be clear, because this is an email actually that from the Clinton lawyers. You have this actually. To be clear, at no point were we opposed to the creation of a record of the interview, which is why we offered to allow the note takers previously. They go on. You have this email, sir. So I guess my question to you is, do you want to sit down and ask President Clinton questions? Actually, can I have my time back?
Will the ranking member
We'll recognize Garcia, then Mr. Donald will be next. So
thank you. So my question to you, Mr. Comer, again, is if we want to actually ask questions of President Clinton, of which those of us in the minority want to do, then let's get him in. Let's negotiate a recorded transcription of that interview to further our investigation. I thank you for the yield, Mr. Lynch.
Time's expired. Chair recognizes Mr. Donalds.
Chairman, point of clarification. Both President Clinton and Secretary Clinton were subpoenaed by this committee to come in for a transcribed interview. Is that correct?
For a deposition.
Excuse me, for a deposition. Chairman, I've been in these closed depositions a number of times in my time being on the Oversight Committee. I fail to see what President Clinton's talking about with respect to a dignified manner. Every time I've been involved in any of these conversations, even when it was former President Biden's son came in for one of those, and I'm not trying to bring up all the Hunter stuff, it's just a point I'm making. I think everybody just take the temperature down, relax. Even those the closed door depositions have always been held in a dignified manner. Members have had questions outside of questions from committee staff, but members on both sides of the aisle had an ability to answer those questions. Those interviews are recorded. The transcripts of those interviews are provided to the public. I fail to see what special accommodations President Clinton and Secretary Clinton were looking for. Chairman, can you help me understand this? Or even a ranking member. I'm really trying to understand. I'm not trying to make a point. We do too much of that here. I'm trying to understand, because if we're holding a new meeting to replace what the committee already requested, my question is why?
Mr. Garcia is willing to answer the question.
Yeah. Thank you, Mr. Donalds. I appreciate the question. Look, I think the committee first, I'm not here to defend the Clintons, to be clear. That's their job is to negotiate with the committee, and in this case, you have the majority. Their job is to negotiate with the majority on coming in for a binding subpoena, to be clear. But I'll also note that this committee has historically made accommodations for a variety of folks. In fact, I think it is a bit hypocritical that when this very subpoena for the Clintons were actually made, I believe there were an additional 5 to 6 other subpoenas that were issued to numerous other